We're going live.
Thank you. So good morning, everyone. This is a meeting of it's Thursday, January 21st, 8:30, a meeting of the Senate Natural Resources and Energy Committee, and we are joined this morning by our colleagues from the House Natural Resource, Fish and Wildlife Committee. We'll be spending the morning looking at Executive Order number 0221, a reorganization of the Natural Resources Board. And we're going to be taking testimony from a variety of people, getting help from legal counsel, as well as hearing from some people in the field, district commissioners and others, as well as the administration. The administration had some time constraints in terms of when they could join us, so they'll be joining us in the middle of the morning. It might be more ideal if they've been able to go early on to sort of pitch the EO to us, but we'll work with the timing we have, even if it's a little awkward. Just to remind everyone of the basics, so if everyone could mute their speakers if you're not the speaker at that moment, and we have a pretty good sized crew, so I'll call on people. I try to scan the screen for hands up. I think everyone knows that down under the how to put a yellow hand or a blue hand seems to vary by system sometimes. But if I don't recognize you, please just turn on your speaker and sing out, because sometimes I do miss the hand. So we have a lot of testimony to cover this morning. In the next 3 hours, we'll be going roughly an hour and taking a 10-minute break and repeating that through the morning, aiming to adjourn by 11:50 so that no one is jammed into any kind of noontime commitment. I would ask people, because we have so many of us and so many witnesses to talk with, to not enter sort of full discussion mode where we ask lots of questions, but at the same, so that we can make sure that we get through everyone's presentation. At the same time, if there's something that's unclear, please do go ahead and ask, because just like being in school, when one person asks a question, there's usually other people in the classroom who would have liked to have heard that. They needed that same question asked on their behalf as well. So before we go to our first witnesses, I just wanted to ask Chair Sheldon if she had anything she wanted to offer up.
Not at this time. That was a good intro, and our committee did get a look at the executive order yesterday afternoon, but I don't think it will hurt us to hear some things again. So thank you for having us. And
great. And just a little bit more. He just left the screen, but good morning, former Representative Baser from my neighbor here in Bristol and a district commissioner. Sorry, once you left your chair, I was saying hello.
I'm back.
Good to see you again. In terms of framing what we're going to be looking at, so we're really looking at the EO from two different perspectives. One is the content. So what does the EO propose to do and why? That gets into an examination of its merits, just as an idea. A good idea can come from anywhere. So is this a good idea? But there's also a process element to it. And that is, does this EO conform to the statutory process that we all, legislators and the executive branch alike, are obligated to follow? And as we address these two aspects, we're going to start with our legal team, Ms. Czachowski, Mr. Martland, and Ms. Arajali, to look at both content and process. And then we'll move on to witnesses who are here primarily to talk about content, I think, today. But so with all that teed up, I'd like to turn to Ms. Czachowski, and I figure that you Ms. Albergelli and Mr. Martland will switch back and forth as you need to. We can leave this pretty fluid as to how you help one another cover all the territory we need to cover this morning. So with that.
Sure, although would it be, so Ellen Tchaikovsky, Office of Legislative Counsel, would it be most helpful to have Luke and Amarin start with the legal framework, or would you like me to talk about the details of the text of the EO's policy proposal?
I thought if we would just start with to make sure everyone knows the content side
Sure.
first before we get into the legal intricacies of how it works or doesn't work, that kind of thing. Thank you.
All right, so good morning. This is, can you see my shared screen of the PowerPoint?
Yes, thank you.
Okay. So this PowerPoint is similar, almost identical to the one I gave yesterday in House Natural Resources. There was one typo that I will point out as we go. So Executive Order 2-21, a reorganization of the Natural Resources Board, was signed on a week ago, January 14th. It is the authority for this, my colleagues will talk about, is under 3000 3 VSA 2002, and that sets a 90-day parameter for the legislature to respond. And we'll talk about that more momentarily, but the structure of the EO is similar to how your resolutions look. It starts with a few whereas clauses, and those clauses set out some of the justification, some of the history of the Act 250 program, and a little bit of the policy details. But then there is a now therefore section which lists the details of the proposal. So there are 9 now therefore paragraphs. So now therefore the governor proposes to reorganize the Natural Resources Board and the district commissions as follows. Starting on July 1, 2021, the Natural Resources Board changes from 5 members to 3 full-time professional members. I did also, under my name for today on your website, this presentation appears, but also the chart that Senator Westman requested, detailing sort of a visual side-by-side. That is up there too, and we can talk about that more later. But to start, the current Natural Resources Board has a full-time chair and 4 other members that receive per diem and necessary expenses. The chair of the current Natural Resources Board serves at the pleasure of the governor, while the other 4 members are removable for cause only. Paragraph 2 abolishes the current board and transfers its duties and authority to the new board. Paragraph 3, the new chair and 2 members shall be appointed by the governor with the advice and consent of the Senate. They shall serve at the pleasure of the governor and have 6-year terms. They shall have staggered initial terms and be full-time exempt employees. So this is one of the major changes. We're going from 5 members to 3 members. Those members will be full-time professional employees, but they will all 3 serve at the pleasure of the governor, as opposed to the current structure, which has removable for cause only. Also in paragraph 3, when the board takes up an application, 2 district commissioners from the district where the project is located join the board as voting members. So the chair of that district commission shall select which members participate. So that means it is a board of 5 people reviewing an application, but each application will have a slightly different makeup of a board reviewing it. Paragraph 4, the district commissioner's authority to decide whether an application is a major or a minor application is transferred to the board. No input from the district commissions. Paragraph 5, The district commission's authority to decide whether to issue an administrative amendment is transferred to the board. No input from the district commissions. Paragraph 6, the district commission's authority over major applications and minor applications with a hearing, that is also transferred to the board. And we'll come back to that on the next slide quickly. Paragraph 7, the statutes, rules, policies, and procedures relating to applications shall be transferred to the new board. Paragraph 8, an applicant may seek reconsideration of a jurisdictional opinion that has been issued by a district coordinator from the board. So I want to point out to the members of the House, yesterday I sort of mischaracterized this process a little bit. So a person may request a jurisdictional opinion currently, and that goes to the district coordinator. Once that has been issued, they may request, the person requesting may request a reconsideration, and that is currently done by the district coordinator also. Someone can also appeal the JO directly to the court. So the reconsideration is an optional step, but under this policy proposal in the EO, reconsideration is now done by the board. And then finally, in paragraph 9, applications made before July 1 remain with the district commission. So this is a pretty short executive order. It's only, this section, these 9 paragraphs, is only about a page and a half, but there is a lot of policy sort of change happening here. So then I wanted to mention, in reading the text of the executive order, it appeared to me, at least initially, that all of the district commission's authority was being transferred to the board. But then in rereading, one of the whereas clauses states that major applications will be sent to the board. And then further, in the press release associated with the executive order, it states that minor applications will remain with the district commissions. So in this being a short executive order, a lot of the details are not included. But I think that what's happening here is because the new board is being vested with all of this authority, they will have the authority to delegate some of that authority back to the district commission. So there are some details that may need to be filled in. And should this executive order proposal go into effect, there will probably need to be legislation conforming the statutes, amending all of this in statute, so some of the details can be discussed then. And also, so this proposal should sound a little bit familiar, although your committee did not review it last year, or the Senate committee did not review it last year. It was a very similar proposal was made to House Natural Resources last year. Last January, it was proposed by the administration and BNRC. The House committee worked on that proposal for about 6 weeks and did include it in the version of H926 that the committee voted out last February. As we talked about briefly on Friday, after H926 left House Natural Resources, it went to House Ways and Means, but also House Appropriations. And the proposal for the new board was removed by House Appropriations in its strike all amendment. And then finally, just as a reminder, H926 was passed. You recall we spent a lot of time working on that, and the governor vetoed H926 on October 5th, 2020, and issued Executive Order 0420. In his veto message of H926, he stated that he was issuing EO 420 to address interim trail policy, recreational trail policy, and he adopted some of the recreational trail policy that was in H926. So it's worth pointing out that this is the second time in 3 months that the governor has issued an executive order proposing to adopt some of the Act 250 policy that your committee worked on last year. And that is all I have in this slide. So that's the overview of the policy proposal in the text of the executive order.
Okay. Are you able to put up your side by side so we could take a look at that together as well?
Sure.
Can I just,
this is, yeah,
can-
Senator Westman.
can I just butt in and say thank you to her for doing that?
You are welcome. Can you see it on the
Yes.
screen? Let me see if I can make it a little bit bigger. So one of the challenges I've already sort of mentioned is that this is an executive order that contains a lot of information in a short document. So I think I've captured all of it in this chart, but this chart is not does not describe the Act 250 program and process completely. I tried to sort of stick to one of the things that are being discussed in the executive order. So this should all largely be redundant to what I just said. It starts with the Natural Resources Board. The left or middle column is the existing structure, and the far right column has what is contained in the executive order's proposal. So current structure, 5 members, 1 full-time chair, 4 members who receive per diem and expenses, appointed by the governor with advice and consent to the Senate. The EO proposes 3 full-time exempt employee members, all appointed by the governor with the advice and consent of the Senate. All of those, again, being employees that serve at the pleasure of the governor, whereas the current structure has the chair serving at the pleasure of the governor with the other 4 members being removable for cause only. Another sort of small detail is that currently in 6021, the statute says, in making these appointments, the governor and the Senate shall give consideration to experience, expertise, or skills relating to the environment or land use. In the executive order, in addition to those skills in environment or land use, it also adds geographic, gender, ethnic, or racial diversity. And that actually was a phrase that was added in H926. So that is language that should seem familiar.
Okay. I didn't ask you this question before today, but do you know anything about the history of, can you say a little bit about serves at the pleasure of versus removable for cause? I don't know if anyone has been removed for cause. They're all, so that's one question. And the other one that goes with it is, are all the appointments made by the governor whenever a seat opens, whether at the district commission level or on the board level, are all the appointments made by the governor?
Yes. So at least as it is stated in statute, I was going to talk about the district commissions next, but all of them are currently appointed by the governor. The phrase removable for cause only is, I am not an expert on the nuances of employment law, but one of the differences is there is at least an appearance of being insulated, from personal or political pressure. So that is a difference. Serving at the pleasure of the governor allows the governor to remove that person at any time from the office, I believe, without having to state a reason, as opposed to cause needs to have a clear reason associated with it. So I can look into more of that. Also, I can do some more research on that for you also.
Okay, thanks. Yeah, sorry I interrupted with that question. So
then as far as the district commissions go, there are 9 environmental district commissions established in statute. It does not appear that any of the structures are changing. That at least is not mentioned in the executive order. So it's unclear, but they're not referenced. Each consists of a chair and 2 members, which are appointed by the governor. The chair serves for a 4-year term and serves at the pleasure of the governor. The other 2 district commissioners have 2-year terms and are removable for cause only. So none of this is discussed directly in the EO. So it's I sort of assume that it is unchanged. Next, jurisdictional opinions. I did just touch on that in the slideshow. So a district coordinator issues a jurisdictional opinion when someone asks for one. The applicant or the requester can request a reconsideration of the JO once it's been issued. And currently the district coordinator does that. They also could appeal directly to the environmental court. As I mentioned, the executive order is proposing to change who does the reconsideration. That will now be done by the board if requested. So then the permit application process is changing under the EO as proposed. So currently a permit application is submitted to a district commission where the project is located. The text of the EO states that the permit will now be submitted. The permit application will be submitted to the new board. Currently, the district commission determines if that application is a major application, a minor application, or would fall as an administrative amendment, which is a much shorter, quicker process. Under the new proposal in the executive order, the new board determines if it's a major, minor, or administrative amendment. And then the district commission from the district where the project is located reviews that application and decides whether to issue a permit. They're also the ones that conduct any hearings that would be needed on that permit application. Under the executive order, the new board plus 2 district commissioners from the district where the project is located review major applications and decide whether to issue a permit. The chair of the district commission selects which 2 district commissioners will join the board for each application. And then finally, appeals. Appeals are not mentioned in the executive order, but currently permit decisions are appealable to the Environmental Division of the Superior Court. Subsequent appeals are made to the Supreme Court. So it does not appear that that is changing under the EO, but it is not discussed.
Great. Well, thank you very much. And I know that this is not your proposal, so it's a little awkward to ask you to explain someone else's proposal, especially when the language of the EO is a bit terse. So we'll have the administration in to dig into that further. Any questions in the room for Ms. Schakowsky before we switch over and start looking at the legal side with Mr. Martland and Ms. Abergele? Okay. So thank you, and let's move on. And I don't know who of council is going to go next. Mr. Martland, are you walking us through?
I'll begin that, and thank you very much. And good morning, everyone. Luke Martland, Director of Legislative Counsel and Chief Counsel to the General Assembly. And I'm joined not only by Ellen, who you've heard from, but also my colleague Amarin. And we'll be discussing the process. And for those of you on the House Committee, you've heard this testimony yesterday. I still will run through it so the Senate committee can hear the same information, but we'll try to be quick. As the chair began his introductory remarks, we welcome questions. I'll leave that up to the chair to recognize anyone who raises their hand. But if anything I say or we say is unclear, please ask us a question. So as Ellen alluded to, there's a process for the House and the Senate to consider an executive order that reorganizes the functions or duties of the executive branch. And that is set forth in Title III, Chapter 41. Pursuant to that chapter, the governor may propose changes in the organization of the executive branch or in the assignment of functions among its units that he or she considers necessary for efficient administration. And the procedure to follow is set forth in 3 VSA 2002. That statute states that the executive order proposing such a reorganization must be submitted to both the House and the Senate on or before January 15th of the year. The proposed reorganization will then become effective, quote, unless disapproved by resolution by either House of the General Assembly within 90 days or before final adjournment of that annual session, whichever comes first, end quote. The remaining sections of this chapter, 3 VSA 2003 through 2007, concern other issues, for example, appropriations, how money follows any reorganization, terms of appointees, and other issues that I don't think are relevant to the committee's discussion today, but we could always answer questions if you think that information is relevant. So therefore, in sum, the process set forth in statute is quite straightforward. Number one, the governor must issue the executive order before January 15th, which was done in this case. Number two, the executive order may propose reorganization to executive branch agencies or departments. Number three, if either the House or the Senate passes a resolution within 90 days or before adjournment disapproving the executive order, the reorganization does not go into effect. And number four, if neither the House or Senate does so, then the executive order will go into effect and the reorganization will take place. Now, in the memo that all of you have been provided, we give a little context. This statute has been in effect for approximately 50 years. It's been used multiple times by multiple administrations. It's been used previously by Governor Scott, and we summarize that in the paragraph on page 2. I won't go into that today unless there's a question, but it is a statute that has been used multiple times, and some of those executive orders have gone into effect and others have been disapproved by a resolution of either the House or the Senate. I would pause here for a moment to see if there's any questions.
Senator McDonald?
For those listening in from the public, and to put it into less legal terms, if you were in a used car lot, you might say take it or leave it. And if this were in the legislature or a committee, the chair would say hearing no objection. Is that basically what we have before us, something we could either take or leave, or takes place unless we object?
Well, let me break that down a little bit, because you raise a question that I think hits on another question we heard yesterday. So first of all, is it take it or leave it in the sense that you can amend the EO? And our answer is we believe not. The EO as it is take it or leave it. You can't amend it or change it. But if you like what the EO does, you do nothing. And if the House does nothing and the Senate does nothing, it goes into effect. If you don't like what the EO does for whatever reason, then one body would pass a resolution disapproving it, and it would not go into effect. Did that answer your question, Senator? I believe you're muted.
He looks contented.
Okay.
Yes, it answers my question. We can, either the House or the Senate can take it or leave it. Thank you.
Yes, thank you. So the only other point that I would make, and this is on page 2 and 3 of the memo, is that there is an inaccuracy in the language of both executive orders. They state that both houses must pass the resolution disapproving the EO. That is incorrect. Under the clear terms of the statute that I read to you a few moments ago, it's either body. So either the House or the Senate passes a resolution disapproving the EO. It does not go into effect. And I'd ask Ameren if she has any comments, but otherwise that concludes my summary of the procedure.
I do not. Thank you.
Thank you.
Okay. I have a quick question, Mr. Martland. On the previous EOs issued by this administration, did they include the language that asserted that both bodies needed to object in order to disapprove of the EO?
No, they did not. So both EOs before the General Assembly currently have identical language. The executive orders from 2017 also had language that was identical between those three EOs, but it was different. And what it merely stated was that the EOs in 2017 would go into effect unless disapproved by the General Assembly. And then there was a citation to the statute. So that phrasing we think is substantially accurate. The phrasing in the current EOs is not accurate.
Okay. Thank you. And are you or Ms. Abergele going to speak about the extent of change contemplated by this EO versus the intent of 3 VSA 2001 and 2?
I don't know if that's our role. I think actually probably the person who could give you most information about that would be Ellen. If you're asking what the line is between reorganization and substantive policy changes, I think that's a little bit of a gray area. Because if you're making organizational changes, that could indeed lead to substantive changes. So I don't think legally we can tell you exactly where that line is, but I think as Ellen has very carefully put in front of you, the impact of these organizational changes is broad, and it does hit a number of different areas.
Right. Thank you. Any questions for Mr. Martland or Ms. Abergele? Senator McCormick.
Thanks. I understand the 90-day deadline for the legislature to act or not. But what is the purpose of the deadline for the governor to issue the executive order in the first place? I believe you said January 15th.
Yes, that's accurate.
What
simply-
is the purpose of that?
I can't comment on the purpose. That's in statute. The statute was passed in 1970, so I'm sorry, I can't tell you the purpose for that, but that is very clearly set forth in the statute.
Yeah. Let me rephrase the question then. What is the function of that? What impact does that have?
I think I'd give you the same answer. The impact is if it's done on January 16th, it's too late. If it's done on January 14th, it's in time, and that's what happened in this case.
No, I understand that. Okay.
Yeah.
This is outside your bailiwick, and I get you.
Yes.
Okay. Representative Dolan.
Thank you. Good morning. My question is about precedent. Say that this executive order goes into law either through lack of action on the executive order. How does it affect that inconsistency, that inaccuracy that you pointed out? Does it become precedent for future executive orders? Or as you had pointed out, we would need to respond anyway to change in statute to support the executive order. I presume it may trigger a relook at that particular language.
So as to your question about precedent, I can't comment from the executive branch's perspective. So maybe they would think that it would establish a precedent for future EOs. As far as interpreting the statute, I don't think it would change what the statute says. And if this statute was ever litigated, I think a court would look at the clear wording of the statute and perhaps any prior cases. And I cite in the memo the only case we're aware of that interprets this statute. So as far as a court would go, I don't think the EO would have much precedential value. Their argument, or I shouldn't say their argument, their language in EO, as I indicate in the memo in a footnote, is sort of having it more than one way simultaneously. And it seems to be an effort to raise the bar, or seem to raise the bar for you in the General Assembly and what you must do to disapprove it. So it's not only inaccurate, I think, as your attorney, as Ellen and myself and Amron as your attorneys, we don't think you should go along with this incorrect interpretation of law. And that's separate from whether you allow this to go into effect or not. It might be something you consider where you respond to this inaccurate interpretation of the statute. But I don't think it has much precedential value for the future. Your other question was about amending the statute. Of course, you could do that, or amending other statutes to comply with the executive order. We think you should do that if the executive order goes into effect. That is what you've done in the past with executive orders, and we think that's important to make sure that statutes comply with any organizational changes.
Thank you. Senator Westman?
So because I heard the 15th deadline, does that mean that if the governor's office wanted to reissue the order, that's impossible until next year?
I believe so. I mean, I think they've submitted their 2 executive orders. That's it. I don't think they can come out with a new one or rework this and reissue it. I don't believe they can.
So there's no it's either up or down for us. You question, you've raised the question of whether or not this is, and this is not the best terminology, but from a layperson, whether this is legal that they did this anyways. And so it's up or down for us, and there's no opportunity to negotiate with them to come back with anything.
As far as approving the executive order, I believe it is up or down. You either let it go into effect or you disapprove it. And as I said earlier, I don't think you can amend it. I don't think they can come back with a new and modified executive order. Of course, it could be the beginning of a discussion that ultimately results in statutory change, which has happened in the past.
I get that, but what I'm just trying to figure out is, in this realm, in this avenue that has been taken, it's either accept or reject, and this process, other than going through a statute change, is basically, in your opinion, a dead alley.
I'm sorry, I don't know what you mean by dead alley.
They can't reissue. We couldn't negotiate for them to. It would have to be through statute.
Yes, that is my point of view. Yes.
Okay.
Senator Campion?
Thanks, Mr. Chair. I'm sorry, I may have missed this earlier, Mr. Martland. When you were speaking with Senator Westman, did you say that you believe there's a legal issue with them having even put the EO forward?
No.
No, okay.
And sorry if I was unclear.
Nope.
They met the deadline in statute.
Yeah.
So they're submitting these EOs to you was proper. It complied with the statutory deadline. No problem there.
Okay.
The only legal issue we raised was their interpretation of whether both bodies need to disapprove it or not.
Thank you so much.
Thank you.
Okay.
Thank you. That was helpful.
Yeah. Representative Lefebvre.
Thank you, Mr. Chair. If an executive order is rejected by the legislature, Can it be brought back in the form of a bill?
Yes, I mean, obviously it'd be a different vehicle, but yes, the same idea could be advanced pursuant to a bill.
Thank you.
Okay. I don't see any more
Mr. Chair.
questions. Yes, Senator McDonald.
If I may, often there are times when there's a general consensus about what ought to happen. The legislators of both parties and various committees agree. People are in accord. And in those cases, in order to save time and energy, governors are perhaps even urged by all the ones I just mentioned to put forth an executive order, and all sorts of time and effort is removed and everybody leaves happy. So I guess the question before both the House and the Senate is whether or not this is one of those times. Thank you.
Anyone else have a question for council before we change gears here and hear from some of our other guests this morning? Okay, so thank you, Ms. Schakowsky, Ms. Aberjali, and Mr. Martland. Will you be staying with us for the balance of the morning or part of it? Okay, so great. I'm hoping that when we wrap up this morning, we'll also return to discussions with council. I'm guessing that at that point, we might have questions to put on to ask them to look into things after we've heard all the other testimony. Or you may have new questions by then, having heard the administration, for instance, and from our folks in the field. So our next scheduled guest is Mr. Stanek, and I don't see him in the room at the moment. So just let me check with Jude to make sure that I'm not missing something.
No,
Mr. Stanek has not
no.
arrived? Oh,
No.
okay. All right. Well, we'll see what happens there. Maybe he's going to come in later. We'll then move on to our next witness, and that is Annette Smith. Good morning, Ms. Smith. And just to let people know, timing wise, so it's 9:15. We're going to have a break just before 10, and the administration's coming in at 10. So that gives us about 40 minutes with 3 guests. I'll ask people to aim for about 10 minutes of testimony and a little Q&A time. If we need more, we'll find a way to get it. But for now, on our first survey of the bill and hearing from folks out in the field, we'll try to cover the landscape, even if a little briefly. So good morning, Ms. Smith. Please go ahead.
Good morning, and thank you all for hearing from me today. I appreciate the invitation. My name is Annette Smith. I'm Executive Director of Vermonters for a Clean Environment. I have a hard stop at 9:30 because I am going to join a PUC workshop on their rule change, and my goal is to try and make it more friendly to citizens. And here I'm talking to you about a proposal that actually makes it less friendly to citizens. So let's see, here we go. There's some interesting history here. The governor's authority to reorganize the executive branch was granted by Act 245, signed by Governor Davis a few minutes before he signed Act 250. And then the next act in the series created the Agency of Natural Resources. I do think the findings are relevant. This is an excerpt from one of the findings that resulted from Act 246, and that is that it is the goal of reorganization through coordination of government programs and policies to improve the relationship between citizens and government agencies. So this proposal weakens that relationship, and it clearly applies to Act 250. And it also makes the government less accessible to citizens. These are the more detailed findings. There are some more that I left out. The underlined parts within the policy limits established by the legislature, and should assure its responsiveness to popular control to carry out these policies. administration of policies established by the legislature. Now, I did focus groups with citizens about Act 250 in 2003, and overwhelmingly everyone said the district commission process is the best thing about Act 250. It's what really makes it work. And so the idea of eliminating the role of hearings by district commissions is very concerning. So the governor's executive order improperly interferes with the legislature's established policy for the role of district commissions. It's provided in Chapter 151 as an essential part of legislative policy. This order strips the district commissions of many of their functions, and also a non-professional board like the NRB is part of the policy established by the legislature. As this is somewhat redundant, so I'll move on quickly, but this is the history of what happened. The big difference between what passed out of the Natural Resources Fish and Wildlife Committee and this executive order is that the appointment process was using the Judicial Nominating Board and not serving at the pleasure of the governor. This slide could be titled, Act 250 is broken right now. It is. It's not fully staffed. The commissioner positions are not being filled. Some expired terms aren't filled. The political appointment process is resulting in political appointments. And so you see that with each administration. This is a short list. I could go on and on about the issues that need to be looked at right now with how Act 250 is being administered. It's being degraded to the point that, for instance, with party status, I'm beginning to realize that I think it's easier to get standing at the Public Utility Commission than it is in Act 250. And that should concern everyone. The citizen participation in Act 250 is greatly reduced. There's no open application process for district commissioners. We have a lot of talent in Vermont, and that's something to look at. This is probably the most important part that I have to offer you, and that is that in terms of this executive order, if you allow it to take effect, then you are also out of sync with your budgeting process. This proposal involves, last year, the salaries were $145,000 each, plus equivalent payments for 2 district commissioners. They were proposed to be paid for by large fee increases that would all be paid by all applicants, but only the majors would benefit from this professional board as it is proposed in the EO. And so I believe that your consideration of the merits of this proposal should occur only after disapproval of the EO. And then you can consider it and other ideas as part of your normal legislative process, which includes budgeting. But if this EO does not allow time for the legislature to make changes prior to April 15th, when your budgeting process still, in my experience, usually goes on until mid-May or later. And so allowing this to go in without grappling with all of the other issues with Act 250 and the budgets for the NRB, and it just does not make any sense for you to allow this to go into effect. And Ed Stanek gave excellent testimony, and I believe that link will work, that goes into the numbers and provides some further insight into this fee business. And it talked about the number of cases. So that is my input for today, but I would strongly recommend that you disapprove this and then move on with your work. Last year, we were, 2018 had the Commission on Act 250. It did good work. 2019, the House committee started grappling with all these really complicated issues. They did a good job developing a bill. And then everybody was blindsided by this deal, which derailed their good process. And now here we go again. I mean, we need an honest legislative process about updating Act 250. Nobody disagrees that we shouldn't be making changes to Act 250, but let's do it in a typical legislative process where it's not already predetermined what the outcome is going to be. There are huge problems with this professional board idea, as we have seen with how challenging it is to participate at the Public Utility Commission. There are great stories about the district commission process enabling the average Vermonter to show up at a hearing, be heard, not have to have a lawyer. It cuts the cost for everyone. There's a lot of money involved in this proposal, and I think that that's a big factor. But the most important part of it is, how do we have an accessible process? Because when it comes to protecting the environment, it is the citizens who are protecting their neighborhoods, and they're called NIMBYs, and they're told that they're just selfish. But when you actually look at it, it is the people who live in the area, who know the most about it, who are the best witnesses at the district commission, and you don't have to have a lawyer to do it. So I really appreciate you hearing from me, and thank you. I'm available for any questions.
Okay. Any questions for Ms. Smith? Okay, well, thank you for highlighting the interesting connection between the underlying statute to reorganize and its connection to Act 250 itself. It's illuminating. So, I do have a quick question. It's a little bit off your presentation, but one of the other concerns I've heard expressed is that district commissions may issue rulings that are quote unquote inconsistent. And I don't know if you've given any thought to the notion that that inconsistency may be a question of perspective. One person might say this is that brings a local voice to a local project, so that's something like local control or local culture, local ethos, whatever we want to call it, and therefore it's appropriate, versus it's inconsistent because a similar project was judged differently in Maidstone versus in South Burlington. So is this fit into your examination so far of Act 250? And
yes, and I should say that I've been a student of permit reform since 2000. It's like every 2 years it comes up. So I've got files, and it's like we're living in Groundhog Day. So this is something that we've heard over and over again. So I have two responses to it. Whatever issues there are with inconsistency and how the commissions are run can be addressed by better training. There's no reason not to have training for commissioners. And I do think that the commissioners per diem should be increased as it was proposed last year. The other answer I have is that I have now, in the last 20 years, worked all over Vermont. And I will say that every town has its own personality. Every region has its own personality. And what goes on in my county of Rutland County is very different from what is happening in, for instance, Chittenden County. And when I did my focus groups, I went to, 8 different regions. And it was only when we got to Chittenden County that we started dealing with housing developments. Everywhere else, it was quarries and transfer stations and things that affect rural areas. And so I think that Act 250 was designed by its nature to be able to have each region reflect its regional differences. And by trying to centralize it and make it one overall guidance for the state, you're ignoring the fact that every region really does have its unique aspects to it. And I think that it's something that is a benefit to the state and not a detriment.
okay, well, great. Well, thank you very much for fitting us in. Good luck across the street, quote unquote, across the street at the PUC. And thank you. Yeah, I'm just going to take a quick look and make sure I'm not overlooking anybody's hand. Okay, so thank you, Ms. Smith.
Thank you very much.
With that, I'd like to move on to welcome former Representative Fred Baser to the committee, and my neighbor. It's nice to see you, Fred, without a mask on when we're out on the street. We're both masked. And you're the chair of District 9, isn't that right? So please, you've heard how we've covered so far. Love to hear, now from district commission folks who are doing this work day by day to hear about the proposal. And I'll just add one more little lead in. Sometimes I think the struggle we go through with Act 250 discussions and reform is a lack of a clear definition of the problem being solved. I'm not really sure, and we'll ask the administration this, what problem they're seeking to address in this EO. But as someone out in the field doing this work, it would be helpful for all of us to hear your take on the EO. And
Sure. Well, that
turn it
was
over to
a
you.
perfect segue, Mr. Chair, to I guess really what I wanted to focus on. I had a conversation with Commissioner Porter a few days ago. He called me and he clearly outlined the reasons why they wanted to make this change to the process, changing the commission structure. Number one was the consistency issue in permit rulings. And two was to bring some expertise and technical knowledge to the commission, to the commissions acting on applications throughout the state. From my perspective, I've been the chair of the District 9 Commission, which is Addison County, for 2 years. Some have been longer, some have been less, but I think I have a pretty good grasp of the process. And to Annette's point, and yours, I think the perspective is important. People are all different, and you're going to get different perspectives from different parts of the state. It happens in many important areas. Look at the judicial system. Does every court case come out exactly the same? It doesn't. They can vary quite a bit given what's been put forward. And I'll give you an example of the localness and the influence that it can have on decision making. In statute, there's a clear ability for fees to be charged for more cars being generated by a project, so that V-Trans can perhaps put a roundabout or a light or something like that on a major state thoroughfare. We had an application for an industry in Middlebury that, because of the number of employees, was going to trip this law being effective, and a handsome 5-digit number in extra fees was going to be paid because of what all the traffic that might exit the entity and go down the road and hit Route 7. What the law, in its strictest sense, didn't note was that there is actually 2 outlets on this industrial avenue that this new building and its employees would have. One was to Route 7, but one was to local roads, where there were actually, once it hit a certain intersection, 3 places for people to go. And it was on the other access other than Route 7, where the commercial activity and most of the residents in Middlebury were located. So we felt that we would modify, and we did modify fairly significantly the fee that was going to be charged due to the V-Trans scenario, because we felt it was burdensome and wasn't accurate given the alternatives workers would have. Perhaps in another community and another set of circumstances, that wouldn't have happened and the full fee would have been charged. It happens reasonably regularly, from what I understand, where you're going to have local situations that demand or suggest changes. And I think it's a positive thing. Concerning the professionalism and technical expertise, when I first heard that as the commission chair, I said, do they think we're stupid? Do they, does the governor's office think that Fred Baser, Tim Taylor, and so many others don't have good common sense? I think we all do. I can't speak to every commission and every commission chair, but I work hard to try to understand what's going on. And the way things work now, we have a lot of expertise available to us. You have the district coordinator, you have legal as part of the Natural Resource Board, you have the ability to access state commissions, whether it's archaeological, whether it's natural resource oriented when it comes to water control, etc. All these things are available to us. And there's a process that allows us to ask those questions of those folks. Plus, applicants almost always, especially in a major scenario, bring experts, quote unquote, to the table to give us their interpretation or their understanding of, the back corridor, and if we change it, or is it sufficient, et cetera, so that someone with common sense and reasonable intelligence, you don't need a PhD, serving on a commission, has access to information that can be presented to us in layman's terms, so that we can do the work to make common sense decisions on whether a development is appropriate or not, and if it's appropriate, whether there's some things that need to be modified in order to protect the environment or protect neighbors or whatever the case might be. Also, to Annette's point, when the commissions were established decades ago by some very good people, I think Senator Gibb from our Addison County, once again, was very active in this. I think they made good sense in having citizens, basically volunteers of the public, to be the ones that are going to sit down and look at projects that fall under the Act 250 jurisdiction and make decisions on how these things will impact their neighbors, how these things are going to impact the environment. And I think that grassroots, if you will, decision-making on important matters is one of the strengths that Vermont has always had. I don't know what's happened in the last decades that would warrant making this kind of a change for a full-time board, basically, and stripping, as I understand, most of the responsibilities that local commissioners might have, with the exception of hearings when it comes to majors. The last point I guess I wanted to make was the way things are here is the chemistry between 3 full-time people who are making over 100K to do their work, paired with 2 local commissioners who basically are volunteers and making a decision on a major application. Every bone in my body, instincts say that is awkward. That's an awkward scenario, and to take it a step further, with 9 commissions around the state or districts around the state, they have the potential of working with a minimum of 18 different people, assuming there's a major in every district. And since there are more than 3 commissioners, we have 6 in Addison County at the moment, because you have alternates to deal with things like people recusing themselves. They could have 26, 30 different commissioners that they would be dealing with on the local basis. From a communication standpoint, both ways, I think that's a very awkward situation. Lastly, I had sent something to Jude, which she may pass out, with some quick questions I had on the process that the governor outlined. You touched, it was some of it was touched on by Leg Counsel. Who can fire the full-time commissioners and under what circumstances? What happens if a full-time commissioner recuses themselves? Now you have 4, an even number, not desirable. So how would that be dealt with if a full-time commissioner feels they have a conflict of interest in taking up an application? Could the 2 local commissioners be paid? I can tell you there's going to be a problem in recruiting local commissioners with this. I had asked someone, because we had a vacancy, just days before the executive order, and I got an email from the person I had asked to consider serving on our commission saying, with the governor's executive order, is there any merit? Should I move on? And I said, well, let's wait until the legislature deals with this. But I think it might be hard to recruit local commissioners given the status that they're going to have here.
Mr. Boehner, just so
all this is another issue, which was also brought up.
Right. The recruitment, just so I understand, are you saying if it turns out that the district commissions will be relegated to just doing amendments or minors that are referred back to it by the full board, are you saying that that'll make it harder because the mix of work is going to be changed compared to what you have now, a blend of majors and minors?
the mix of work will change dramatically. And I guess the answer is yes. And I question, I'm getting better, as we all do, at things that we work at for a period of time. You learn more. We're always learning. And with the many aspects to Act 250, major, minor, administrative, the challenges with one of the criterias can all be different. Did you lose me or can you hear me?
You can hear you, yeah.
Okay. Having people be on the board consistently for a period of time, I think, is very important in terms of them handling applications and doing the best job with them. And I think this current system that's being proposed would be a problem for that.
Okay.
And recruiting people to serve.
Right. Well, I'm looking around the room to see if I don't see any yellow hands up. Anyone want to wave at me, holler out? Okay, well, thank you very much, Mr. Baser. Great to hear a report from the field. And with that, I'd like to go on to another district commissioner who's joined us this morning, Mr. Taylor. Good morning.
Hello, folks. Thank you for this opportunity. I'm Tim Taylor, and I'm the chair of District 3, and I've been doing this for about 10 years now, since 2011. I know a few of you in the room. I'm a farmer. My wife and I have Crossroad Farm. We live in Thetford, Vermont, near Lake Fairleigh. And Chair Sheldon knows me, and some of you in the House know me too. So I've submitted something, and maybe I'll get through most of it, maybe I won't, but I just want you to know that Act 250 is probably one of the most significantly important things that's been in my life. So I went to Vermont Law School before I farmed for 40 years. I'm still farming full time, and I'm pushing 70 now. And when I graduated, I had the pleasure of having my clerkship with none other than Jonathan Brownell and Norris Hoyt. And I could tell you some great stories about that, but we don't have time for that. Then I took up farming, and we had a little 15 acres. And having been in law school, I really didn't know what the heck I was doing, as you can imagine, when we started this farm in 1980, the same time our child Mariah was born. So adjacent to us was 20 acres of some of the nicest farmland that you could ever want to grow on. And a fellow by the name of George Huntington was proposing 10 2-acre lots there. And of course, that triggered Act 250. And lo and behold, the District 3 Act 250 Commission, which ironically I've chaired now for a while, decided, Alice Flannery, Senator McCormick probably remembers her very well, I bet, was chairing at the time, and said, no, you violated 3 out of the 4 9B prime ag soil issues, and they decided against it. He turned around, he was a smart man, and sold us the land. And that became the cornerstone for our farm for the last 40 years, of which we've fed the Upper Valley quite significantly. And right after that, in the later 80s, a proposal came for 56 houses right behind us. Once again, Act 250 stepped in. They saved the 20 acres of farmland there and pushed the houses into the woods. And lo and behold, we have a conserved farm with Vermont Land Trust now, 56 acres. And we are one of the, I like to think of us as one of the, more important, we succeeded anyway. We're here in the Upper Valley doing our job. What I do want to point out to you folks in being District 3 is that our district covers Randolph, it covers little towns like Granville, so it covers Hartford, it covers Newberry. We even go into Addison County, way up on the mountain to the Snow Bowl. So I have a little experience. I've conducted about 70 of these hearings. And what I think you need to consider is, and you'll see this in my submittal, but when you look at this issue, this executive order, which is not very different from some of what was proposed last year, is this proposal in keeping with the Act 250 Commission? I mean, why did we have the commission for 2 years if now we're just simply going in another direction? Has there been a history of this inconsistent decision-making? And I'd like to point out there, and I might elaborate, that probably 70% of the cases we've handled, the issue comes down to criteria 8, which, if anyone knows, that's the aesthetic criteria. And that one has to do with the sensibilities. Is it so offensive to the sensibilities of an average person as to render it a violation of Act 250? And so that one allows for extremely particular circumstances and particular cases throughout the state. And there's different facts every time. And we've solved those problems by permitting almost every single one of them, however, with conditions. So it gets done. But the point is, it's an average person standard. This doesn't require experts. If we need experts under rulemaking, we can get experts. If we need legal help, we can get it. We did turn to the Natural Resources Board, and there they are, 2 attorneys that are very helpful to us. Another one, our issues that I mentioned, the complex issue a little bit. Physical austerity, this will be extremely expensive. We work for $50 a day right now. And then this has been mentioned before, but I think it's the cornerstone to it. Do you want to reduce Dean Davis's core principle that Act 250 be decentralized and be accessible to Vermonters? Now, for me, some of the most important things that happen in a hearing, and sometimes, let me just give you a quick rundown of how this works, generally speaking. My coordinator, Linda Matson, who has years and years of experience of this, will get an application. She will review it. She will send out an email to me, and in that, she will usually have a little bit of advice. She'll give me the link to the website that I go on to look at it, and to the other 2 commissioners as well. She will make a suggestion as to whether she thinks it might be a major or minor. And, in these times, we're trying to make things as easy as we can. So we've been pushing out a lot of minors if we can do it. So we work really hard to make it a minor if we can. But remember, so what'll happen is that comes in, if it's deemed complete, then we issue the permit right away within 30 days. Now, that permit goes out. When it goes out, it has the opportunity for the neighbors to respond or the state agencies to respond. If they request a hearing at that point, it goes to hearing. It has nothing to do with us. It goes to hearing. All they have to do is show a particularized interest. Okay, so we try to get the application complete. We try to get it in and review and make sure that all the boxes are checked so that this permit will stand up and will go out as a minor. As you'll see in my statistics that I show from 2018, almost all of them went out as either administrative amendments or minors. There were very few hearings, I think something on the order of 35, of which only 5 of those were appealed to the environmental court. So really, what problem are we discussing? This is a very, very stable law that has had in my time, in my 10 years, very little changes made to it. The Queechy test still stands, as I've mentioned, for criteria 8. But to wrap up, what is so important to me is when I conduct a hearing, I let folks know that I am not the state. Maybe I am the state, but I'm not. I'm a layperson. I'm just like them. If I were to come in to a comparable Act 250 hearing, I'd be coming in just like they do as a citizen. And that as I conduct the hearing, I really direct myself to the questions that they have. And then what makes me the most satisfied is if at the end of that hearing, they come up to me and say, hey, thank you. I know you probably don't agree with me, but you listened to me. And that made my day. And thank you very much. That's what the process is largely about, is listening and hearing, being empathetic, being neighborly, being Vermont. That's the way I look at it. So I could go on forever about it. So with that, I'll just pass it back to you all.
Okay. Any questions for Mr. Taylor? Okay. Senator McCormick.
Thanks. First of all, before a question, just a comment. Since I once had your job I have a particular proprietary sense about the District 3 Commission, and it sounds like not much has changed. And I want to also point out, when you mentioned your farm in Thetford, the importance of ag land in Thetford because of Thetford's location relative to the Connecticut River and relative to the Upper Valley. There's not a lot of good farmland, not a lot of good bottomland in eastern Vermont. It's not a coincidence that most of our farming is in the Northwest, which is the Champlain Valley. That's precious land. It's important land. Also, the proximity of Thetford to Hanover, Hartford, Lebanon, the so-called Tri-Town area, which means it really is, it wants to become a bedroom community. And we're not going to preserve that land through market forces. It's going to be preserved through a little bit of social engineering. And so thank you for your good work. And we'll get together someday and talk about Alice Flannery.
Well, it's one quick comment, Senator McCormick. It's not without notice that I'm sitting next to a saber field of the Upper Valley. That's the Connecticut River. And that's actually a collage, a study for 1999 Upper Valley. So she's one of my favorites.
Yep.
My dog ate her chickens in 1978. That's how we met.
There's so many ways to meet your neighbors in Vermont.
Yes. Right. Well, thank you for this opportunity.
Okay. Well, it's interesting to hear you describe the law as intentionally decentralized. And I've gone back and read the Addison Independent archives for when the governor and Art Gibb presented on the bill in Middlebury back in 1970. And it's just interesting reading. And they acknowledge there'll be some pushback, but that it was essential work that needed to get started. So I think it's never had a totally smooth road, but meaningful conversations between people are not always that easy to engage in. I wanted to go back to something Ms. Smith brought up, and that was local access. So if these meetings were moved to quote unquote the professional board, I mean, at the current moment, everyone's virtually the same distance away from any meeting, but I'm imagining at some point we'll all be sitting at tables again together. And I'm just wondering the degree to which you think it would change the nature of the process to have to be at a professional board meeting as opposed to a local district commission meeting.
Well, I think that's what I sort of indicated. Again, it does have to do with the personality of the individual chair largely and how they comport themselves. But I think the history is there, and that being a lay person, you have a kind of empathy, and you don't ever get jaundiced in the same way that potentially a professional does. I remember one time one of my commissioners was texting on the phone while we were listening to testimony, and after that, I really talked to that person. I said, "No, if you're going to do this, you need to give your full attention to them. That's very important." So I think there would be a degree more of intimidation without that. When we did Exit 4, if you remember Sam Samus wanting to do what would have been the largest projects in Staff's Flats, there were 160 plus people in the room, but I stood up and I went around the room and I directed myself to each individual and I had them introduce themselves. It took some time, but I think it was very important to do that. And so I just don't see where the problem is. I really don't, especially when you see so few of these going to appeal to the district, to the environmental court. I think there are things to discuss about changing Act 250, maybe a change in jurisdiction, but I wouldn't be touching what we do as civilians, as lay people. I think we're doing a good job.
Okay. Any questions for Mr. Taylor before we take a break here? Okay, so thank you to everyone who's here and participating. We're going to take a break till 10 o'clock, at which point the administration will be joining us. So we'll learn some more about the executive order. The streaming, the public YouTube streaming will continue throughout the break. So I suggest that you mute and stop your video so you don't reveal more to the world than you intended on a break. Okay.
We online now?
Senator McDonald, we are online, but the committee's on break. So
I
don't know
just
if you
wanted to
heard-
say hi to Tim, who's one of my constituents, and I enjoyed visiting, but I didn't want to take up everyone's time to say that. So Tim, if you're here and still hanging on, hello.
Yes, I'm still here.
Oh, wonderful. Thank
Yeah.
you for taking the time this morning to speak to everybody.
Oh, you're welcome. It's my
I'm
pleasure.
ordering seeds this week.
Well, you better get to it. It's the demand for seeds is unbelievable. Unbelievable.
I understand. And when I stop at your place, it's usually to do stuff that I haven't planted well or holes and things that haven't gone well. So you better get yours too.
Yeah, I've got mine all sorted out. I'm ready to go. We start tomatoes next week.
Okay. Oh,
Yeah.
oh, you're ahead of me.
We'll keep up the good work, and I hope you all agree. And there's just a lot to do with Act 250, but I just don't think we've given a fair shake on this. We're given a fair shake as individual lay people here.
Yeah. Well,
But good luck with listening.
I don't blame the powers that be for introducing an executive order. And if we accept it, I'm sure they'd be happy, but I think that's part of a broader discussion. And thanks for sharing your.
Yeah, you're welcome.
Yeah.
Have a great session. I hope things work out for you all. It's a tough way to do it, but I like your cows. That's great. All righty. I'll say goodbye now.
Okay. Bye.
Take care.
Yep.
Okay, let's see. Jude, can you hear me okay?
Yes.
Okay, thank you.
The administration haven't checked in yet, so I'll see where they are.
Okay, I see Commissioner Porter, but
Yes, and
I see Chair Snelling. Good
Right.
morning.
and Greg.
All right, we'll wait just another minute.
Jude, if I may, Mr. Chair, I know Secretary Moore was in testimony at House Appropriations and is back to back on testimony there and then here. So it may be running over there a couple minutes.
Okay, and Jay Johnson Pershing Johnson was going to be joining us as well. I don't see her yet either. Okay. Well, let's do one thing for ourselves here while we're waiting for the rest of the guests to assemble. And I skipped over this on my own notes from this morning, which was to pause and just go around the room because it's a new session, committees have changed, and we all haven't necessarily met each other. So I just thought we would just say for everyone who's on the two committees, and so that the public listening in, we're all labeled these days on Zoom, but it's not quite the same as saying hello. So sorry for that oversight. I skipped my own outline, and I'll ask to just go through your committee alphabetically, and with that, I'll just jump in, starting with our own committee. So my name is Chris Bray, and I represent the Addison Senate District. This is a test of whether everyone knows where they are in the alphabet. So
Brian?
Senator Campion would be next. And his Hollywood square is black. So let's move on.
Mark McDonald, Orange County. Seth Bongartz. The first sighting I've seen you since we served in the House long ago.
I'm Dick McCormick.
Yes.
I'm Dick McCormick, former chair of the District 3 Environmental Commission.
Senator Westman.
I'm Rich Westman. I'm the senator from Memorial.
Senator Bray, I'm back. I apologize.
You just need to say who you are, where you're from. Please.
Yes, no, I understand that. Senator Campion, Bennington County and Wilmington. Always great to be with the House, especially Chair Sheldon and Representative Bongartz, and wonderful to see the former Senator Diane Snelling joining us.
All right, so how about the House team there?
We've never tried to do alphabetical, but I think we should give it the old college try.
Well, we set the bar a little bit low there, so take a whack at it.
Yeah. I think that puts
Nelson Brownell, representing Pownell and Woodford from Bennington 1.
Seth Bongartz, representing Bennington 4, Arlington, Manchester, Sandgate, and Sunderland, or almost all of Sunderland. Share a little bit of it with Representative Durfee. And my district mate, Kathleen James, but Seth Bongartz.
And not sure if Representative Dolan's with us. She's also was headed to House Appropriations.
I am here.
All right.
Representative Dolan from Washington 7 District, which includes Facein, Duxbury, Moortown, Waitsfield, and Warren. Thank you.
All right, it gets more confusing. Paul, I think you're up.
Yeah, I was confused. Paul LaFave from Newark, I represent 6 towns in northern Essex County, 1 town in Orleans County, and 1 town in Caledonia County, which is my own. Thank you.
Representative Morgan.
Excuse me. Good morning. I'm Leland Morgan. I represent all of Grand Isle County and the western portion of Milton.
Okay, I think that completes our, no? Is that
No,
completed?
doesn't, we're not even,
No.
we have Representative Morris. Are you in the room?
I am. Thank you very much, Madam Chair. Christy Morris, representing the large town of Springfield.
Oh, I don't know if Harvey Smith, I think he might have left. Amy Sheldon, I represent Middlebury. And
I'm here. Larry Satkowitz, represent Orange, Washington, Addison District.
Oh, thanks. Sorry, Larry.
That's all right.
And Representative Terenzini may have left also.
Okay. All right. Well, I don't see any other squares to uncover here. So thank you, everyone. And we're going to recommence. Welcome to Secretary Moore, I see, Commissioner Porter, Ms. Johnson, and I don't know if you have anyone else with you, and I'm not seeing them on the screen here. Okay, so just so you'll know where we've been so far this morning, we did 2 things. We started with our own Ledge Council. We looked, and we've been looking at the bill from the EO, excuse me, from 2 perspectives. One, in terms of the content, what's the idea here and what are its merits? We've had a little feedback from some district commissioners, and the other thing that Ledge Council helped us take a look at is the legal structure of the bill. So for instance, not to be too opaque about this, for instance, the provision that the EO outlines for having a rejection, should it not be approved, that both House and Senate must disapprove. So we're doing both, and I thought maybe we would follow the same path we started this morning, which was start with the content. You know, what's the idea? Why'd you bring the bill forward? I always figure again, I said bill, EO. You know, when we start any bill in committee, we always start with the same 2 questions. What opportunity or problem do you see? And how does the proposal you're making address one or both? So with that, Secretary Moore, I'll ask you to run your team and feel free to move back and forth, call on, defer to each other, etc. So thanks for coming.
You're welcome, Senator. Thank you for having me this morning. I will keep my remarks rather brief, but I'm also happy to ask or answer questions folks might have once I complete them about the content. I think at its most basic, the proposal is getting at the fact that Act 250 currently isn't well positioned necessarily to grow and evolve and remain relevant in a world that is increasingly complicated and frankly litigious. And there are challenges associated with the decentralized model of district commissions and the really important, robust, and technical, deeply technical issues that at times are coming before the commissions. And so the proposal to professionalize the Natural Resources Board and create full-time staff positions for reviewing major applications. And those are the applications where those most complicated issues tend to arise, would allow for board members to develop experience and expertise, drawing from the talent within the Agency of Natural Resources and other parts of state government, but to really serve that role that Act 250 plays in protecting Vermont's natural resources. I would add that I think it's important to, or I would guess I would not want it to go without saying that we are committed to the protection of natural resources. This isn't an effort, frankly, to undermine the protections afforded by Act 250 and the important regulatory tool that it is, but rather really this reflection of the increasingly complex world that we're operating in. And that a model that has served us very well for 50 years is not particularly well positioned necessarily to serve us well into the future. And maybe just pause there with an opportunity if folks have specific questions about the content, I'm happy to take them up, but thought it was important to start with that kind of framing.
Sure. Thank you. I'm looking around to see if I don't see any hands at the moment. Okay. Senator Campion.
Madam Secretary, good to see you.
Nice to see you too.
I don't know if you were on prior to now listening at all to some of you weren't. Okay. So there's great, significant concern about taking this away from, I'm sorry, is Senator Bray, is that your phone?
Not me.
Okay. Taking this away from local control isn't really quite the way I want to say it, but folks that know their communities differ even, from miles away from one another. So could you say something about that and why you moved in that direction?
Yeah, well, and I think it's important to acknowledge that was we had a lot of discussion around that in the House Natural Resources Committee during the last biennium when we initially had brought forward this proposal as part of a larger Act 250 modernization package. And the discussion in that committee is reflected in the EO in that the proposal in front of you has those 3 permanent or full-time board members augmented by 2 representatives of the local district. The intention there is to provide that consistency while at the same time making sure that local concerns and issues have a voice at the table and in the process. And we think that strikes an important balance between sort of allowing people to accrue the depth of knowledge needed to take on some of these more complicated tasks, balanced against the perspective of folks who live in the area on the ground and can anticipate the impacts it could have for their communities.
Thank you for that. And just may I, Mr. Chair, follow up?
Please.
I'm just for my own clarification, Secretary Moore, are those individuals, are they in the decision-making camp? In other words, are they making decisions, those local representatives? Or are they similar to what one might consider to be a witness, coming in, talking and informing those that are actually going to make the decisions?
They would be participating with the board in the conversation. I would actually need to defer to Jay. I apologize in that I don't remember if we had talked both about having them have a voting role or an advisory role, and I can't remember where that landed. My apologies.
That's okay. Is it okay if Ms. Johnson responds to that?
Yes, please.
It's contemplated that they have a voting role on the issue which is affecting their district.
Okay. So may I just take that? So if a community is sending 2 representatives, and is it 2 representatives from each town, or is it's more geographic? Is it sort of like
it's drawn from the district commission?
Oh, from the district, right? From the district commission. So, Ms. Johnson, you're saying that those during a particular case, those 2 individuals would vote. It would be really a vote of 5 instead of 3.
That's correct.
Okay, thank you.
Senator McDonald?
It was just stated that the district commission would send 2 people. I believe my understanding was that the board above would select 2 people. Which is it?
The district commissioner, the chair of the district commission, chooses 2 commissioners to sit with the Natural Resources Board on the issue.
Not the Natural Resources Board selecting the two.
No.
Thank you.
Okay. You know, we've talked with you a lot over the years about Act 250, and there sometimes it's a challenging area of law to talk about because there are a lot of different impressions of what's going on, and so it would be helpful, I think, for the committees to hear about. You mentioned, for instance, consistency, and I think that's one of the things I've heard mentioned quite a few times. And there's a tension between consistency and local decision making that reflects the local, you might say, the personality of the district and the inhabitants of that district as they review a permit. And so I'm wondering about, on the consistency side, what particular problems are you seeing that make you, you know, what have you seen specifically that makes you conclude that there is a problem that merits being addressed out there?
Sure, I can start with a state agency example actually drawn from VTrans, but then may turn it over to Louis and he can speak to it, perhaps some more specific examples from his department. The example from VTrans is regarding the application of the 10-acre threshold to pre-existing development. As you may be aware, different bridge and exit replacement projects at times exceed that threshold. And there have been differing opinions as to when VTrans needs to seek an Act 250 permit, depending on the jurisdictional opinion issued in that particular by that particular district commission. I think most recently there were concerns around the project they're pursuing at exit 17 off of I-89, but this is something that has come up for them before and is maybe the easiest example to point to about the types of concerns that come up. I don't know, Louis, if there's anything you would add.
The only thing I'd add is a general comment, which is I think that the chair is right. It's a balance between wanting local voice, local information, local feelings, and a statewide consistent approach to cases and what cases are judged on and how they're judged. And I think that's exactly why the EO is structured as it is, to include both of those elements. So you will have consistent application from the full-time board members, and you will also have input from those who know the local area and community best. What we see now is quite significant differences at times across the commissions, understandably so, because they are all from those regional or local areas, and they are informed by past cases that they work on.
And you're mentioning past cases. So can you say, this may be a question more from Ms. Johnson. I don't know the degree, or also the NRV is here with us this morning, the degree to which an opinion issued by a district commission like a JO has, you know, precedential power or influence over future decisions. Can they, you know, to some degree, must they all be quote unquote consistent, or is there an allowable degree of variation that reflects the facts on the ground, because literally every application is unique in some ways, you know?
I think, Chair, that is a question probably best put to the NRB and either Chair Snelling or Greg Boble, her attorney.
Okay, so we'll hold on to that one. And Mr. Boble, if you can help me not forget to come back to that, that would be helpful. Thanks.
Sure.
You know, so I'll just bring forward something that some of the district commissioners who are in here shared with us. And that was that on the question of technical expertise, that they felt as though they were well enough resourced that however complex the application became, that they could draw on A&R assistants and other experts in order to come up to speed on the issues in front of them. So do you have a response. I'm not trying to debate. I'm just trying to bring forward things we've already heard this morning. Do you have any thoughts on that?
Yeah, and I think that that is both the opportunity and the challenge. We have compiled the number of hours A&R staff spend participating in Act 250 on average each year. And it works out to be about $750,000 worth of staff time. And part of that is because it is a more significant lift, working with 9 different district commissions, the rotating memberships of those commissions to provide that technical assistance and education. Lewis can certainly speak to that in more detail, but that's one of our most significant concerns, is that it is a really significant demand on agency staff time. And to the extent we're working with a smaller group that can build expertise over time, we are anticipating that will reduce the demands on our staff time. And that is significant in this area, or this time of constrained and finite resources. I don't know, Lewis, if there's anything you'd add there.
Yes, thank you, Secretary Moore. I second everything you said. For the Fish and Wildlife Department, it's give or take $300,000 a year on Act 250, depending on the number of projects. We do not receive funding for that from the applicants, from the developers. We pay for that essentially from funds we get from hunters, anglers, and trappers, or from recreational shooters through federal aid money. But I would like to go back briefly, because I did have the opportunity and advantage of hearing your prior testimony. And I think that the folks you had from the district commissions, who I have a tremendous amount of respect personally and for the work they do on behalf of their communities in the state, made an interesting point. I think it was Fred Baser said, well, we have access to district coordinators, and we have access to the experts from the applicants, and we have access to the state agencies, all of which is true, all of which is an important part of the process. But I would just suggest to you that some additional expertise and experience and knowledge among those making the decisions would help those decisions not be as subject to the direction of any of those groups that I just mentioned. All of those groups have important input to the process, important expertise that they do and should bring to bear. But I do think that what is a volunteer board of citizens can be subject to the expert opinions that come before them, and would benefit from greater experience, knowledge, and longevity on making those decisions and gaining knowledge themselves. I don't know if that makes sense, Mr. Chair, if I'm getting my point across, but I think that when you hear the list of people who are relied on, all good people, but all who have their own perspective and their own interests in the case. Thank you.
Okay. You and the Secretary have mentioned the cost-related aspects, and we're sensitive to that. As a matter of fact, we've had a discussion last year and already started one this year, getting ready for this session, about finding funding for Fish and Wildlife so that you're remunerated for your efforts in supporting Act 250 applications, like the environmental impact assessment work you have to do. So we're certainly we're cognizant that people basically, we need to pay for the services we're expecting for government, and we should, you shouldn't just have to stretch your budget further and further every year. That said, have you analyzed, maybe it's a Madam Secretary question, the relative costs of providing technical expertise out to the 9 DCs versus building more centralized expertise on a board with full-time professional staffing?
At this point, Chair, we haven't taken our analysis to that level. We went through the work of trying to come up with a realistic estimate across the agency of staff time spent on reviewing and participating in Act 250 proceedings, but haven't yet forecast what the reduction in those demands is anticipated to be as a result of a centralized structure. I'm happy to take that analysis to the next level, just recognizing it would be a bit of a swag.
I would only add to that, Mr. Chair, if I could, that it goes beyond the scope of an EO or a governor's executive order authority, but we are interested in having a discussion with these two committees and others in the legislature about those services, how they're paid, whether there's a more efficient and better way to provide those services, and so on. So it's not that we're ignoring that part of the conversation, just it goes beyond the scope of an EO. Thank you.
Sure. Senator Campion? And then, sorry, I see some, now I do see other hands up, so I'll keep going.
Do you anticipate the administration putting forward a fee bill this year?
No, I don't. Not that implicates ANR fees at this point in time. Although, as Commissioner Porter indicated, we do anticipate that there will be a larger Act 250 modernization proposal that the administration supports that will be introduced. And that does include the wildlife permit component of it, which is one of the mechanisms we're looking at in terms of providing financial support to the department for their engagement in Act 250. But in terms of a specific fee bill, we are not anticipating that this year.
If I may add to that briefly, and I apologize for the tag team here. If it gets too much, just let me know. A fish and wildlife fee bill would not do much to answer the concern that I have here, because our fees are levied on hunters, anglers, and trappers. My concern is that we are providing a service that benefits both certainly the resource, but also project applicants and project opponents, for which there is not a funding mechanism put into place. So a fee bill would not address that, Senator Campion. Thank you.
No, I appreciate that. Yeah, that wasn't, I was just curious in general with regard to a fee bill. I mean, this isn't, we're hearing that across the state agencies are stretched, and so it's just a general question. Thank you, Mr. Chair.
Next up will be Chair Sheldon, then Senator McCormick, Representative Dolan, and Representative Lefebvre. Sorry if that's not the order in which you raised your hands, but I see 4 hands up now, so we'll go right down the line.
Thank you. Thanks, Chair Bray. Since we're talking about money, I'm hoping the agency can, you told us how much you spend on ANR or on Act 250 permits a year. How much do you receive from Act 250 fees every year?
I will let Louis correct me if I'm wrong, because he's been a little bit more in the details, but it's on the order of, I believe, $200,000 a year.
Okay, thanks. And then how much will the new professional board cost, and how are you proposing to pay for that?
So that is a good question. We've really focused in thinking about the cost on the cost of making the transition. I think in making this transition, there are probably some larger opportunities for looking at the structure of the NRB overall and thinking that through. But we haven't gone to those steps beyond just affecting the transition. We anticipate, however, that in the first year, and I believe this information was presented in your committee last year, Chair Sheldon, and we haven't revised it since then, that we anticipate it would take between $500,000 and $600,000 to make that transition.
Can I just,
sorry.
Have you identified a source for that money?
I don't want to get out in front of the governor and presenting his budget, but I am anticipating it would take the form of a one-time allocation.
Thank you.
Okay. Anything more, Representative Sheldon?
No, thanks.
Okay. Senator McCormick.
Thanks. Over the years, someone said earlier that this is sort of like Groundhog Day. It's not only the constant complaints about Act 250, but it's always the same complaints. And they're the ones that were predicted by Dean Davis himself. And one of them that I've heard is something referred to as, quote, you guys in Montpelier. And it's that you guys in Montpelier don't trust local local communities, and that there's too much top down from you guys in Montpelier. I've got to say it's very surprising that we would take power away from the community and concentrate it up with you guys in Montpelier. But the other thing I want to say, having chaired a district commission, is that the expertise issue matters. It's a quasi-judicial board. The chair is a quasi-judge, but not a. I think these days the chair is usually law trained. I was not law trained when I chaired the commission, but I got to tell you, I spent a lot of time on the phone to Montpelier and got guidance from the council to the state then environmental board. But you also that there, you don't have to be an expert yourself to have the intelligence and capacity for attention to take expert testimony and understand it and ask the questions necessary when you don't. So I guess if I have a question, that was a speech and I apologize. For my question is this: you said that the Act 250 is not well positioned to deal with current development issues. And I'm wondering if you could go into a little more detail. What is the problem that if we have too much local control, what is the problem with local control that this is intended to fix?
Sure. And I apologize, Senator. I may have not been as clear as I could have been in my remarks. Really, our focus is on looking at the interests the General Assembly has expressed in new criteria, sort of reflecting the larger evolution of our regulatory landscape. There are places now that ANR has permitting and regulatory authority that certainly didn't exist when Act 250 came into being. And there are places that clearly are important to our environmental goals moving forward. Obviously, the body spent a long time last session discussing a forest fragmentation criteria. I know that in House Natural, there was also discussion around a climate change criteria. And really what I was endeavoring to reflect is, to the extent we're going to take on new areas within Act 250 that are technically complex and will require a significant sort of startup relative to their administration, I think that this sort of reformed board structure would serve us exceedingly well and create the capacity for Act 250 to take on these next generation challenges. It's less a reflection of current conditions on the ground, although there is a piece of that, and more frankly, forward-looking at what my understanding has been this body's interest is, as well as my own agency's interest in the role Act 250 can play going forward.
Okay, Mr. Chairman, I'm still not sure what the problem is we're being asked to fix with this executive order, but we have time. We have 90 days.
So
Thank
going
you.
down, thank you. Going down the line, Representative Dolan.
Thank you, and good morning. Good to see you again today.
Yes.
My question, and thank you for coming in to help explain the nuances of this executive order. My question is about cost. When we think about public participation at the local level, that is all about accessibility of the process by the public to weigh in on important matters that are affecting their livelihood, their communities. And so that cost for public participation matters. When we centralize it, I presume it may end up resulting in increasing the cost of an individual wishing to participate in a process such as Act 250 proceedings. And I think what this proposal somewhat looks like is a public utility commission that is able to manage some of those costs with a whole department to represent the public interest. The public advocate is the Department of Public Service, with the quasi-judicial board being a centralized board to hear testimony. So I guess my question is, and yet that is because of the legal nature of those proceedings, it ends up requiring legal support to shepherd forward proposals in front of the Public Utility Commission. So have you evaluated some of these costs that that may be borne by the citizens of Vermont or residents of Vermont for participating in Act 250 proceedings?
I wouldn't say we've done that specifically or explicitly, but I do think it's important to keep that to state upfront that the intention is not to modify the opportunities for public participation, appreciating very much sort of the look and feel of Act 250. And that it does allow for concerned neighbors and local residents to have a platform to raise issues and concerns and voice opinions. There's no intention to move away from that. And I think there are ways to be cognizant of those needs, including having hearings take place in the district where the application hailed from, that will continue to be important tools as we move forward.
If I might just add briefly to that, this proposal would add capacity to the NRB. The current capacity that exists would remain, and it would add capacity at least in the form of 3 professional full-time board members who would do work in addition to the current staff at NRB, as I read it anyway. So I think that would provide additional ability to manage that from what exists now in the.
And Representative Lefebvre, thank you for waiting so patiently.
Thank you. You're welcome. My question for the commissioner, he mentioned his department spends about $300,000 a year. Is that on both major and minor projects, Commissioner?
That is across our Act 250 work, and that's a variable number based on the number of projects and the complexity of projects. But yes, it's across our Act 250 work. In general, the vast majority is on major projects. The minors are relatively quick. Stuff.
Am I correct in assuming that that's the kind of work you do to determine if a project will have an impact on a habitat or a wildlife corridor or something along those lines?
Wildlife corridors are not really covered by Act 250 currently, but yes, that's the review and study we do of projects' impact on things like bear habitat, deer wintering yards, riparian areas, things like that.
And presently, you do not have build-back authority as far as the project developer is concerned. You cannot build back the work you do.
So that's a little bit of a complicated question. There is a statute authorizing A&R build back on this kind of work, but the reality is that the administrative and legal confines on that are so strict, it renders it basically unusable. And I'm happy to go into that in more detail at some other point if you'd like, or now if you'd like. But essentially the sideboards on that and the difficulty of administering it are very strict. Thank you.
My last question is to just follow up with how would that change then? How would the change from district commissions to a professional board impact the amount of money that the department is spending to do this kind of work?
Well, it would change directly because of this EO and the change in structure in one way, which is that we would gain the ability to work in a longer term and narrower way with a smaller number of folks to develop expertise and experience and knowledge. Right now, we spend quite a bit of time in working with district commissions all over the state who, due to the workload, frequently turn over, and we have we sort of rolling a rock uphill in terms of of that work. We're happy to do it because it's an investment in the process, an investment in the district commissions, but it does take a tremendous amount of our work. So that would, the professionalization, the added expertise and longevity would help in that area. But I will say that this executive order does not impose a fee or a change in bill back that would allow us to recoup funds directly. We do contemplate having that conversation, or would like to have that conversation with the legislature in the legislative process that goes beyond the scope of an EO.
Thank you.
Representative LaFave, anything more?
Thank you.
Thank you, Mr. Chair.
Okay. Any other questions focused more on the content side of the executive order at this point? Okay. So then I'd like to change gears a little bit and refer everyone back to probably the most useful thing to take a look at, again, to remind yourself, is the memo that Mr. Martland wrote at the request of the President Pro Tem on the legal status of the executive order. And so I'll boil it down to 2 questions, and I guess I'll address them to Ms. Johnson, and then others, of course, if you have questions you want to chip in, I'll keep an eye out for hands. So Ms. Johnson, thank you for coming. I guess the simplest question is, as we were informed by our counsel, the terms of the executive order require both House and Senate to, should they not want to approve of the executive order, that both bodies must disapprove of the executive order. And the underlying statute talks about either body disapproving is sufficient. And then they pointed out the legislative history where previous EOs by this administration didn't include this must be rejected twice sort of language, and it wasn't challenged by the administration previously. So I'm just wondering if you could explain the thinking behind changing the test that is offered in the language.
Thank you, Mr. Chair. Jay Pershing Johnson, Governor's Legal Counsel. So the difference essentially is to put, I think, to give the legislature notice. The last time we sought reorganization was in 2017, in the first few days of the administration. So we did not challenge the existing structure. We were proceeding as set out in the statute. In the intervening period, we have done a lot more research on separation of powers and bicameral action, and there's a leading case in the U.S. Supreme Court, INS v. Chadha, which you probably are aware of, which is very clear about the constitutionality of a one-house veto. So I think in this executive order, we wanted to be clear that we were putting the General Assembly on notice that that was our position. That said, you may have, and I haven't seen Mr. Martland's memo. There's also a memo from 2017 from Mike O'Grady to Representative Olson on this exact same issue, where Mr. O'Grady goes into the various legal arguments that one might take on this issue. And I've sent that to Jude if the committees are interested. But you might have also heard that yesterday a suit was filed challenging the executive order as well on several grounds, but one of the issues is the constitutionality of the statutory structure in its entirety. So while we believe our position is strong, we also understand that reasonable lawyers can take different views of the law. And since this has been thrown into the court, it's our position we'd like to see the courts decide on the legal issues. We understand that, we're hoping that they understand the timing constraints and would act quickly. And we would like to see the committees continue to work on the merits of the proposal and let the courts make a determination on the legal issues.
Okay. Senator Campion?
So by the legal issues, you're talking specifically about whether or not both House and Senate need to reject in order for this to be rejected.
From my perspective, that's the issue raised by Legislative Counsel. There are other legal issues raised in the complaint in the lawsuit.
And are you, just for clarity, are you saying that Leg Counsel is, my words, mistaken that this just needs to be rejected by one of the two bodies in order for it not to go into effect?
I would say that if you look at Mike O'Grady's memo, you will see that there are two valid positions. I would say that I'm on one side and probably Attorney Martland is on the other. But I think it's important to maybe understand the two issues by looking at that 2017 memo.
What is?
In addition, I think that the court, if the court gets to the merits of the complaint, would be addressing the statutory structure of or the constitutionality of the statutory structure.
What does statute say now about this? I mean, I appreciate that there might be debate, discussion, true with a lot of things that we all do. What does statute say now?
Statute says now that one house must disapprove.
Oh, okay. That's okay. So that's what we should be operating on, I would say. Sure. I mean, things could change. Absolutely. I mean, lawsuits could happen, debate could take place, but okay, thank you.
Sure. I mean, I just would like to point out that since that law was enacted, there is U.S. Supreme Court case law on the constitutionality of a one-house veto.
And so we'll have to look into that further. I guess what becomes a little complicated here is to use the statute whose constitutionality is being challenged, and which you're sort of asserting, like the case at the INSV Chadha, is to use that same statute in order to bring the EO to the legislature at all. So if it's unconstitutional, I'm wondering if it's a constitutional vehicle for even bringing an executive order to the legislature.
Quite honestly, I think the law in total, Section 2001 and Section 2002 of Title III, are very clear that the governor can bring this executive order for restructuring of the executive branch to the legislature. Further, the Constitution provides for a process, bicameral and presentment process, pursuant to which all legislation is enacted. I don't believe that the law fails in its entirety because of this flaw.
Okay. Well, we have more to look into. I mean, I'm comparing that with a bill, right? So a bill is offered, a bill goes through, it has to be approved, not disapproved, by the two bodies and then presented to the governor. So it seems as though with this 90-day clock running and a power only to disapprove, that it puts the legislature into a very different posture than bringing forth a bill that then may be vetoed. So we'll have more to learn on that one. Any other questions on that, the test for whether it's approved or disapproved? Senator McCormick.
Yeah, thanks. I want to make a comment about the one house veto. And invite a response. I guess that would be a question then. The phrasing of an override vote is not shall the veto be sustained. The question is, shall the bill pass, the veto notwithstanding? And so if either house decides not to do that, then you don't have two houses voting to pass the bill. So it does not advance. That is actually, it seems to me what's operating there is the requirement of two houses. And if one house votes not to pass the bill, the governor's veto notwithstanding, then in fact, what has happened is you have not gotten your two houses. The second comment I wanted to make, and again, invite a response, is I have on numerous occasions voted for a bill that I knew full well some people thought was unconstitutional, but I have never voted for a bill that I thought was unconstitutional. The argument, well, let the courts decide, is when you say let the courts decide. If you think the bill is constitutional, let the courts decide is what you say to someone who insists that it's not. And who says, you can't vote for this because I think it's unconstitutional. And I said, well, the courts will have to decide that. Perhaps you would vote for an unconstitutional bill to create a test case. But otherwise, I think we are bound not to pass a bill if we think it's unconstitutional. So my understanding is that, in fact, the statute that allows for a one-house veto of the governor's executive order, I'm using the word veto incorrectly, the one that allows for one house to reject an executive order in this case, I think that may in fact be unconstitutional, and I'd be reluctant to operate under that provision. And I'd welcome a response.
I
Ms.
guess
Johnson,
I'm
anything?
not entirely clear what the question is.
Okay, how do you address the fact that the Vermont Constitution says you have to have both houses?
Well, there are two provisions.
That's the simple.
Well, there are two provisions. One is presentment and bicameral action presentment in order to enact a law. The governor's veto and one house action is contemplated in the Constitution. This, as actually even Senator Bray has corrected himself several times, is not a bill. This is a structure that the legislature itself has constructed. What I'm saying is I don't believe it's as constructed is constitutional. Attorney Martling clearly disagrees. When we have two branches of government with different positions on the law, seems to me prudent to let the third branch decide.
Well, we only have 90 days. We only have 90 days. We have to take some kind of action or not.
Within 90 days.
Decide what, yeah.
And we have
I
some
don't think the
time,
courts are
and you have some time to consider the proposal on the merits.
Separate question.
Sorry, Senator McDonald.
No, I'll just say that's a separate question.
Sure. Has the administration proposed any new language around? I mean, it seems as though what you're asserting is that there's a flaw in the underlying statute. It's unconstitutional. And do you have language to address that flaw in statute that would pave the way for this or, well, future EOs not to run into this controversy?
I personally do not have a proposal for statutory change.
Right. Okay. All right. So any other questions on that? The other area that came up, and it was a quote unquote gray area, was the extent to which the underlying statute contemplates, changes as substantive as what's proposed in outline form in this executive order. Do you have any thoughts on that?
The question is whether these changes are too substantive?
Correct. Rather than reorganization, that it will end up changing statute to create a new board, move powers that currently reside with a district commission, for instance, to the new board, take powers away from existing statutorily empowered district commissions, and then the rules, policies, procedures all follow with it. So it's more than it's more than an org chart change. It's going to have changes throughout statute, law, policy, program.
I believe that Section 202 authorizes the governor in this instance to make changes that are contrary to statute. It expressly contemplates that.
Right. Sure, right. Okay, so I'll leave it there. I mean, I'm not in a position to get into a legal debate over the extent of the change. The question that has come up was how much change is permissible before it is changing policy and things in the purview of the legislature. I guess the other way I've heard that expressed is this statute may, if it's interpreted as giving powers that broad to the executive to write new law, in essence, it may be over delegation to another branch, right?
Well, it sounds as though you may have read the complaint. I would say that since that's being litigated, I would want the courts, I think, to weigh in on that. I would like to point out that as a matter of, say, the emergency powers, which sort of raises the same issue, there is a provision in Chapter 1 of the Constitution regarding the authority of the legislature to suspend the laws. Only the legislature can suspend the laws unless it provides authority to others to do so. Section 202 clearly has done that. And you've done that as well in Title 20 with respect to emergency powers.
Both parties. Yeah.
I'm not seeing any more hands on these questions. Senator McDonald?
So the question that we're contemplating is whether we take this or leave it. Is that correct?
Is that a question for me?
For anybody.
Oh, that's the choice that's given in the law. It's up or down.
Oh, thank you. Good enough for me.
Okay. All right. Anything else members of the administrative team would like to share with us before we move on? Okay. Thank you for, I don't know if you'll be able to stick with us, or some of you. Thank you for coming over and helping us keep the conversation going. As a reminder to everyone, this is day one. We're really doing a pretty rapid scan of the landscape, and we'll come back to more particular questions in days ahead. With that, I'd like to turn to the Natural Resources Board members. And so I see Chair Snelling and Mr. Boble. So good morning, and thank you for joining us. I would want to welcome any kind of remarks you have about the executive order and in response to the discussion you've heard. And Chair Snelling, I saw your hand going up a while ago at some point of.
Not important.
Okay. So please go ahead, and we'd like to hear your thoughts on the proposal in the executive order.
Thank you, and it's great to be here today. I'm Diane Snelling, and chair of the Natural Resources Board in Act 250. And really what I want to say today is a direct response to my experience for the almost 5 years that I've served as chair of the Natural Resources Board. I keep hearing reference to 3 new members of the board, and I just want to remind you that I'm the chair now, and there would be a chair in this proposal. So it's really 2 new members. And I think that when you think about it that way, you can see a very obvious balance between the board members and the local. So to me, the option of that, or the advantage of that, is really gaining a broader experience with which to make these important decisions. So I do support the idea of a full-time board. And I want at the same time to say that our current board of volunteers is very engaged, and yet it's practically impossible to give them sufficient information in a meeting once a month, or even as often as they might be able to meet, that really allows for a deeply informed and engaged conversation about the issues that we encounter every single day at the NRB. So I just wanted you to think about it as what facilitates the goals and purpose of the NRB and Act 250 better than a stronger board to work through those questions. And I guess we'll just leave it at that.
So just to make sure that I understand and others, the current board structure, you're a full-time employee as of the state, and you're chair of that 3-member board, correct?
No,
then,
currently, I'm sorry, Senator, currently there's a chair, myself, who's a full-time member, and 4 volunteer members who are paid per diem to meet. And we have been meeting once a month and sharing, as I say, as much as we can. But it's very difficult in a limited time frame to become as informed, as you all well know, about the complexity of the issues in front of us.
Sure. And the 4 volunteers, are they paid the same per diem like the members of the district commission?
$50, yeah, whatever.
Yeah. Yep. Okay. And what business, I mean, are you, I just want to make sure we know how this works currently. What kind of work comes before the current board?
Discussion of the budget every, the annual budget as we go through the budget process, and any discussions about personnel and staff to some extent, and most directly the policies that are being discussed in the legislature.
Okay. But are any permit applications referred up to the current board?
No.
Okay.
No, my role as chair is in dealing with appeals and enforcement violations, as well as, trying to manage the day-to-day of the processing in 9 districts.
Okay. And what kind of appeals currently come to you or the board?
What kind of appeals?
I mean, are these for jurisdictional opinions, or an application is denied?
Appeals of commission decisions. Greg, help me out here.
Sure. Yeah. Let me. I just wanted to clarify a few things. It's not, and I think you're all aware of this. The Natural Resources Board doesn't currently hear appeals of district commissions or of coordinator decisions regarding jurisdictional opinions. Those appeals both go to the Superior Court Environmental Division, but the Natural Resources Board is a party to those appeals. So to the extent the Natural Resources Board decides to participate in those appeals, and the position that the Natural Resources Board ultimately takes with respect to those appeals is ultimately up to the Natural Resources Board. And just to give a little more background, as a practical matter, the Natural Resources Board has historically delegated a vast amount of the authority that it has with respect to participation in appeals and enforcement and so forth to the chair directly. So the chair, who is in the office day to day, who knows what the issues are, make those sorts of decisions on his or her own without having to defer to the board at large.
Okay, thank you.
There are, by the way, a couple of appeals, types of appeals that the Natural Resources Board has the authority to hear, but which literally never have actually come before the board as far as I am aware, including a provision that allows applicants to appeal a commission's decision regarding fee waiver requests. The board, the Natural Resources Board, also has the authority to hear appeals from energy efficiency determinations by the PUC or by DPS, by the Department of Public Service. Neither of those types of appeals has the Natural Resources board heard, in at least the last 5, 6, 7, 8 years that I'm
So,
aware of.
Mr. Chair, I just wanted to
Yes, ma'am.
clarify, when I said that as the chair of the Natural Resources Board, I get very involved in appeals. It's in strategic conversation with the legal team, which can take up significant amount of time. And all I'm trying to say is that there are very complex arguments that come up all the time in terms of, quick decisions need to be made. And I think that it would be very much to the benefit of the overall system if we had this balance between the full-time board and the very informed and significant influence of the local municipalities and regional planning.
Okay. And in terms of district commissions, I'm just trying to, I'll ask this question now. I see Representative Sheldon. Quick question is, so there are nine district commissions. They have 3 active members plus 3 alternates. Is that right? So total of 6 per commission.
I think it's 4 alternates, Mr. Chair.
Okay, so is it 7 then per district? That's a statutory circumstance, but not necessarily all of those positions are filled. Okay, so of the total, so that would be 63 total district commissioners out there, including alternates. Do you know currently how many we have of the total potential population of 63? I'm sorry, I don't have a number on the top of my head, but it is all listed on the website, and the current terms are on our NRB Vermont webpage. Okay. Well, I'm asking because I have heard over time that at different points, it's hard to fill positions, or boards may be short a chair for a period of time. That puts a strain on the commission. Other district commission chairs end up substituting in, kind of like a traveling judge, I suppose. Do you know if we have? No, that doesn't really happen. The other district chairs don't sit in unless you transfer a project to a different district. Okay. So I don't want you to think it's like, we just make it up because it's a pretty closely monitored process. All right. Well, so obviously I don't know. That's why I'm asking. I just don't. I'm wondering about the staffing level out in the field. Well, I think, as I've told you in the past, Mr. Chair, I made it my intention, following up on my longtime interest in data that helps us understand what the outcomes really are. And I've continued to pursue that and look at and analyze how many projects come into each district, with what variety of types of projects, and what the processing issues are. And I think we have sufficient capacity based on recurring numbers as we are currently staffed in the district commissions. Okay, great. Yeah, I've read your report each year. I don't know if you're working on this year's update. February 15th, it's due, and you will receive it shortly. All right, thank you. Thank you for your patience, Representative Sheldon.
Sure. I think I'm curious about the volume of applications. I mean, actually, Chair Snelling reminded us we're actually subtracting board members and adding two new paid in this proposal. And one of the previous witnesses today mentioned something like 400 applications coming in a year. 6 of them were majors, 6 were appealed, something like that. And I wonder about the capacity of even a professional board to handle the volume of applications that are coming in. So
I really don't see that as a problem. I really think when you consider that 3 full-time people addressing that workload, it should be possible.
And what would their role be in appeals if a lot of your time is taken up already with these appeals?
Well, I see the 3-member board as the administrative board with the same requirements and capacities as the chair currently has as delegated. Right,
Except
Greg?
that you'd actually be here, you'd be making decisions in district commissions, and so that's a huge increase in the workload.
Well, I mean, whatever, I'm sorry, I don't mean to speak out of turn. Whatever is appropriate in that, if the task of the 3+2 is to hear major applications, I think that's a good fit between that as time spent and the additional time that's necessary to continue to refine and improve the outcomes.
Do you know how many cases the Public Utility Commission hears a year?
I don't. Greg, do you know?
I don't know the answer to that question, no.
We do hear about 400 applications in a normal year. This past year, as we all know, is not normal in any way. But it was a very steady, flow of work.
Thank you.
Any other questions for the NRB folks? Team NRB.
Mr. Chair, I'm sorry. I just
Yes.
wanted to remind you that someone had asked earlier about the precedence of jurisdictional opinions, and I think Greg was going to just offer a few comments.
Great, thanks very much.
Yeah, I think Senator Bray, that might have been something you were thinking about earlier in the morning. I think maybe your question was whether or not jurisdictional opinions as issued by coordinators are precedential, and the answer to that question is no, they're not. Jurisdictional opinions that have been appealed and heard by the Superior Court Environmental Division and then the Supreme Court, of course, are precedential, as well as opinions, decisions that were issued by the former Environmental Board. Those decisions currently hold the same precedential value as decisions that have been issued by the Superior Court Environmental Division.
Okay. And how about applications themselves? I mean, the kind of findings and determinations that are made in an application, do those applications, once approved, have that sort of precedential value where someone can cite a previously issued application as evidence that whatever measure they're proposing on their project should be considered adequate and therefore be awarded an approval?
Sure. Applications issued by district commissions are not themselves precedential. Of course, if an application and a decision issued by the district commission is appealed to the Superior Court or then the Supreme Court, those decisions would be precedential. Certainly, it can be argued that decisions issued by district commissions have some persuasive value in other similarly situated cases, but there is no precedential value to those decisions on their own.
Okay, well, and to be direct about it, part of the reason I was asking those questions was to respond to the consistency question, where for some folks, they see inconsistency in jurisdictional opinions or the handling of a particular application as a negative feature, like they are not the same. And other people see it as a positive attribute, namely that the local facts on the ground interpreted by that local district commission led to a judgment that was appropriate for those people at that point in time. And so I don't think there's no perfect right or wrong answer on that one, but I was trying to figure out the consequences of having quote unquote inconsistency in JOs or applications. Chair Snelling.
Yeah, I just wanted to say that, Senator McCormick mentioned this earlier, but from the very beginning of Act 250, the error or the issue, the topic of inconsistency versus consistency has been heard very loudly. So I just want also to keep in mind what's a continuum of concern versus an active deterrent, if you will, in terms of making the decisions. So I think there's actually more consistency and adherence to the law than you might have reported to you.
Okay, well, it's true. The squeaky complainants are noisier than happy customers, right? So, Representative LaFave, then Representative Dolan.
Thank you. My question is, does the Natural Resource Board go to court when there is an appeal on a district commission's decision? Do they weigh in?
I'm sorry, I think I heard the question. The question was, does the Natural Resources Board weigh in on appeals from the district commissions? And
Yes.
okay, yeah. So yeah, yes, the Natural Resources Board does at the court. So appeals from district commissions go directly to the court. And the Natural Resources Board does typically participate in those appeals. Depending on the questions, the legal issues on appeal, there may be some varying level of participation that the Natural Resources Board feels is appropriate, depending on those legal questions. But yes, typically, the board will have at least some level of participation in each appeal from the district commission.
Do you often side with the commission?
I'm sorry, can you repeat?
Yes. Do you often side with the commission?
I would, it's,
I don't just, if I may, Greg, I mean, that is what I was trying to explain before, the decisions of the current chair, circumstances, making those decisions and trying to see what's defensible in court. So there's a ongoing review of where we can succeed and if we value what might become a precedent. Does that answer your question, Representative?
Somewhat, yes. In light of that, does the Natural Resource Board have the authority to hand back a decision to the commissioner and ask them to take another look?
No.
Can you negotiate with the commission before it winds up in court?
I think I'm hearing, does the Natural Resources Board have the authority to send a decision back to the district commission? And no, we don't have that sort of authority right now. And I also just wanted to come back to this question of the position that the Natural Resources Board might take at the environmental court and whether or not that position might be consistent or inconsistent with the district commission's decision. And this is probably review for most of you. You all know that the environmental court hears these applications for Act 250 permits de novo, which means that essentially forgets about or doesn't even acknowledge what was heard below and what the decision of the district commission was, which oftentimes sets up a situation where there's actually a different set of facts presented to the environmental court that may have been presented to the district commission. And sometimes those new facts are a result of the district commission's decision. So the applicant may have changed may have at least slightly amended their project in a manner that would have made their project more amenable to approval by the district commission. So it's sort of difficult for us to say one way or the other whether we support the district commission's decision, because in fact, certain things may have changed in the interim between the application as submitted with the district commission and that which was filed with the, and the evidence that's put on during an environmental court hearing.
Thank you.
Sure.
Representative Dolan?
Thank you. My question is in regards to the consequences should this move forward and the whole concept of reorganization. When we had talked with the secretary a bit earlier today about this proposal in the executive order, what came up was the cost of implementing the executive order, and I think it was alluded to in the secretary's remarks that there may be some additional actions taken to reorganize the NRB to be able to, I think, manage the change in the most cost-effective manner. Can you describe any thoughts pertaining to that? What additional reorganization is anticipated should this executive order come forward or move forward? I think part of that was relying on one-time funding for this year to support the reorg. And it appeared, or it implied, that there was some interest to reorganize the NRB even further to be able to find some cost savings. I guess that would be a question for Mrs. Snelling.
Yeah, I really don't think I've heard of this as a cost saving enterprise. To me, this is about making the decisions be the right decisions that we need to make for the state going forward and the balance between the environment and the economy. So it's not about saving money, because quite honestly, we can't run any more economically lean than we are at the moment. And I say that having just said, I think we have sufficient staffing, which doesn't mean I wouldn't love to contemplate on some what if, there could be others. I would be able to prepare something, but my point is how we work now, it is very lean, and the idea is to strengthen the work that we do, not to reduce dollars. We don't want to spend any extra, though, Representative.
Thank you.
Mr. Chair, if I could respond just briefly on that.
Sure, please.
Thank you. Yeah, Chair Snelling is exactly right. This is about making Act 250 work efficiently and well in achieving its mission. But I think what you may be referring to, Representative Dolan, is there would likely be or may be some capacity at the district coordinator level for them to participate and help in the staff work on applications. And I would defer to the chair and to Greg on that, but it seems to me that without majors being at the district commission, they would have some potentially some capacity to help out on the processing of those at the board level. And I stand ready to be corrected by Greg or by Chair Snelling on that. But
Mr. Chair, I would agree.
Yes, please.
I think, if I may.
Yes, please.
I recall last year in last year's bill, I know this is a new biennium, but since we did spend a significant amount of time thinking about part of this executive order, what's contemplated in this executive order, I think at one point we were talking about, or there was discussion about reducing the number of district commissions. Is that anticipated if we were to move forward with this executive order?
that's not, oh, sorry, go ahead, Chair.
No, go ahead, Louis.
I think we're going to say the same thing, which is No, that's not contemplated in the executive order. Over time, would there potentially be some opportunity to have staff assist at processing applications at the board level? Yes, but that's certainly not part of any discussions I've had. And I would defer to the chair. Thank you.
Yeah, and I would say that my expectation is that coordinators would assist the board. So on the major applications, there would be a balance.
One of the questions that came up this morning from one of the district commissioners was if they are going to participate with a full-time professional board, would they be a bit of a spare wheel when they are participating on that board, the 3+2? So are you thinking that they would be paid at the same rate so that they would, in a certain way, I guess, be treated professionally in terms of pay, so that while they're performing those duties with the other three, that they would, instead of the modest daily honorarium, they would.
Yeah, no,
they would be paid
I absolutely, to me, that's an important piece, is that what we're trying to do is say there's credibility and legitimacy to how these decisions get made. And it's important that the people who are volunteering to bring an important local perspective are being paid at a rate that is comparable to their colleagues on the same panel. I mean, I don't think you want to create a disparity on who comes from where based on what they get paid, or base what they get paid on where they come from. You know, I think you could easily look at it as potentially some multiple of how the two board members, not the chair, but the two board members, whatever their rate of pay is per hour. Okay. You know, so I'm intending to say that there would be no disparity between the two types of board members.
Okay, thank you. Looking for hands. I see Senator McCormick.
Thank you, Mr. Chairman. I guess I'm asking this of Chair Snelling, but whoever else might want to answer. The old environmental board was quasi-judicial, but now you act as advocates. You actually intervene. Are you no longer, is the board no longer quasi-judicial?
Greg, I think that we retain that authority, but we're not acting in that.
Well, I think with respect to it, I think it really depends on what feature we're talking about that the Natural Resources Board participates in. If we're talking about the activity that we participate in concerning appeals to the Superior Court Environmental Division, we're certainly not quasi-judicial. We act as any other party might in those proceedings.
And is that an advocacy role or an expert role?
Well, that's a good question. And I don't know that I'm prepared necessarily to sort of split that hair. The Natural Resources Board decides whether or not and to what extent it might want to participate in any appeal, and will advocate its position one way or the other based on past precedent and law. So to the extent you want to call it expert advice to the Superior Court or advocacy, I'm not sure how to label it one way or the other.
Do you go in on your own initiative, or does someone call you as a witness?
Okay, no, we're certainly not witnesses. But yes, the Natural Resources Board will participate on its own initiative. That authority is delegated from the board to the chair, and the chair ultimately decides based on the opinion, based on input from either myself or my colleague Evan Meenan, as to how we might want to participate and to what extent we might want to participate. From time to time, the court may ask the Natural Resources Board for its opinion and maybe to brief a certain matter. But it's rare that the court would affirmatively ask the board for such a brief.
Do you tend to support appellants or to support the commissions?
I wouldn't say there was a balance one way or another, or a direction one way or another. I think for me, making the decision on whether to represent something and brief the court is about the value of the evidence. And if I feel the evidence is sound and that the decision has been, all aspects of the decision have been considered, then I feel it's worth it. But I have been confronted on innumerable occasions with decisions that have opportunities for substantial, criticism and open to a possibility of losing in court and setting a precedent that we don't want to set. So there's that kind of perspective as well, as how do we invest our energy and resources to promote the best precedents of policy going forward and not overexpose ourselves to losing in court.
Thank you, Mr. Chairman.
Hey, so I didn't want to interrupt. We've gone past the time where we would have taken a break, but I do want to just take a 5-minute break and then we'll come back and finish for the morning. While you're making tea or taking a little walk or whatever, let me just float out something for you to think about. And that is, what questions, the committees will handle them individually, but what questions do we have and who do we want to hear from in order to help us get answers to those questions? And maybe we can have that discussion when we come back. We'll check in with Legislative Counsel to hear their thinking based on what they've heard in testimony today, and then we'll wrap up before noon. So let's take a 5-minute break. See you at 11:37. Thanks.
Campion, are you on there?
Mark, who did you call?
I was calling for Campion.
Oh,
I was, I often look for political lessons and, or things in the movie Animal House. You familiar with can you recite all the episodes or scenes in Animal House? Is that you, McCormick?
Yeah. I can remember a few.
Oh, this reminds me of Flounder going out and buying the 10,000 marbles and throwing them out in front of the ROTC cadets.
I remember the trip to New Haven. That was a good one.
I feel like we're the other one. Oh, and I was thinking of the. Anyway.
Okay.
I loved it. Was the statue of Wheelock with the.
No, there was the other one where the same Flounder takes the guys on a road trip and ends up smashing up the car. And they said, he says, this is my father's car. What am I gonna tell my father? The answer was, tell him you screwed up. You trusted us.
But it's also the guy is crying, and John Belushi tries to cheer him up, and it's just going like that. I actually do that to Cindy when she's got the blues. I'll just go.
I was putting that one on the teachers' retirement stuff.
Okay. 11:37 is here, so let's jump back in. Thank you, everyone. So I think we're only going to go another 10 minutes or so just to finish. We have counsel with us, and I wanted, the two questions I floated out that I think would be helpful for all of us to hear put on one table would be, what questions do we have, and then following up from those, from whom do we need to hear in order to answer those questions? So, I'll start with prime to pump with two questions. One is with questions around the constitutionality of the current statute. What's the legislature's usual reaction? I mean, for instance, there must have been laws found unconstitutional and we changed them in the state of Vermont, but nothing has been brought directly to us. There's apparently a case that's been a suit been brought on this already related to it. So I think I'm looking to Leg Counsel to help provide us for guidance. What would our ordinary procedure be? My sense is we would operate under our current understanding of current law until directed otherwise by the courts. So let me put that question on the table, and maybe we can get just a brief answer to that. And then let's go around and see if there are other questions floating out there. I don't think I can't hear you, Mr. Martland.
No.
Not yet.
While Mr. Martland is working on his technology, Mr. Chair, may I just mention that I hope that, if it is determined that it's really only one committee, one body that needs to deal with this, that decision will then be made, and so that both bodies aren't working on something that they don't need to be working on, if you will.
Right. Well, and to your point, there is always the possibility of this proposal being offered as a bill by any member of the General Assembly. So
Of course.
there's no way that we're precluding a discussion on it, but we've been put into a different posture, like the clock running out, etc. So, Mr. Martland, let's see if you're.
Yes. Can you hear me now?
Yes, sir.
I apologize about that. I had to change the microphone setting. So you were correct, Mr. Chair. The scenario is you have a law on the books that is currently valid. A case has just been filed that may challenge it, but the law is currently valid. It has not been overturned, nor has it been stayed. And you should operate under that law. And that law clearly states a one-body resolution is sufficient to disapprove this executive order. If this committee or any other committee wants to go into the constitutional issues, would be glad to, but I don't think you need to for purposes of considering this executive order.
Okay, thank you. Anyone else in the room have a question that's emerged out of listening to this morning's testimony, whether we can get an answer right now like that, or if it requires research and we can ask Ledge Council to come back or others to come back to us in the future. Senator McCormick.
Thanks. Luke, were the statute under which we operate to be found unconstitutional, how would that finding affect action that we had previously taken under the now unconstitutional statute?
I think it would depend whether the whole chapter is held unconstitutional or only parts thereof. In other words, whether there's a severability analysis applied, so that would be relevant. It also might depend on the court's ruling. So it's hard to predict. I don't know if it would invalidate what you've done. If you pass a resolution disapproving the EO, it doesn't go into effect. And so nothing would change. If you allow the executive order to go into effect and then the statute is held unconstitutional, maybe there would be repercussions, but we'd just have to see. And please remember that we've advised you that if you allow the executive order to go into effect, you should amend other statutes to make sure they conform to the executive order.
Yeah.
We want everything to be harmonious. We don't want conflicts between the executive order and statute down the road.
Okay, I just want to make sure I've got it. If hypothetically, and I understand I'm asking for a conjecture, hypothetically, one house disapproves the executive order, the other house remains silent. Under the present statute, that would invalidate the executive order. Were the court later to then decide that that one house provision is unconstitutional, would the executive order then go into effect?
Negative. I do not believe so.
It would still be disallowed,
Yes.
even though the disallowing was unconstitutional.
Yes, and I think we're getting a little far afield. We can talk about this in more detail if you want to go into those issues. But I would think that if the statute is held unconstitutional, the whole statute falls, which includes the mechanism to bring an EO to the General Assembly to reorganize the executive branch.
Okay, I would hope, Mr. Chairman, maybe not now, but I would like to go deeper into this. Hypothetically, were we to decide that we don't like the executive order, I would want us to make sure to err on the side of caution that we did it in a way that would be sustained regardless. In other words, two houses would be better than one. Thanks, Mr. Chairman.
Thank you. And Representative Dolan and then Representative Lefebvre.
Just a quick question. Is there a difference between an executive order and a bill with respect to the constitutionality issues that were raised? I can see obviously with a bill, the legislature has a constitutional role there with a bicameral two house approach to passing that bill. But when you're dealing with an executive order, is there is it treated differently under this whole question of constitutionality?
I think that's the crux of the issue. And so once again, we're glad to talk about the constitutional issues. I think there's good arguments on either side, but I think there's a gray area there. And Representative Dolan, that would be one of the key questions: is the same bicameral requirement apply or not? But once again, we're sort of backing into this extended conversation. So if you want to go into it, we can reappear before any committee and go into it in detail, and you can hear from the executive branch. But I had the impression the chair just sort of wanted to lay out issues at this point. So I don't want to end up going on and getting into it in depth, if that's okay.
Right. So thank you. It's a good question, and well, I think we're obviously a complicated one. So the two committees will make decisions about how to dig into this further. Representative Lefebvre?
Yes, thank you. Is there any bright line that we could go by to determine whether or not an executive order has surpassed a reorganization?
Ellen, do you want to take that? I think that's something you touched on earlier.
Yeah, so I think the answer is no. I think that reorganization is not defined under the statute 3 VSA 2002. And I think there can be multiple arguments made about what falls into that specifically. So there hasn't been any case law further defining it. So we don't have a bright line, no.
Thank you.
I have a question. Ms. Smith this morning cited, it was an interesting thing she brought up, I think it was Act 246, if I'm remembering, the law that established this ability to reorganize in 3 VSA 2002, et cetera, or Chapter 41. And it talked about things like increasing responsiveness to the public, et cetera. Anyway, there were some features in there, and they were in findings, I believe, in that original law. And I'm wondering about to what degree do the findings of that law influence our, are they just informational for us, or do they have any kind of legal force? Like, do they create, in essence, a set of criteria against which we could judge the suitability or unsuitability of the proposal currently in front of us?
Is that a question you want us to answer, or are you throwing that on the
No,
table for your
definitely,
committee?
yeah, I would like to hear from council on that one. I just don't know how to use that information that's contained in the original legislation that is driving the whole thing today.
I think it's something you certainly could look at if you wish. I mean, legislative findings are intended to either give background on why you're passing a bill, why you think it's important, and or how that bill should be interpreted if there's litigation or applied in the real world. So yes, you can absolutely look at legislative findings, and sometimes courts look at legislative findings to understand how a bill should be interpreted and applied. So you could look at them. They're not binding. They're not like the substantive codified law that says what people can do or not do. So it's a little different, but you could look at them.
Okay, thank you.
Also, I would just quickly add, I looked at them. I didn't fully dive deep and spend a lot of time on them, but I did look to see if they clarify reorganization at all. And I did not see, at least initially, anything further clarifying that aspect. So Ms. Smith was referencing sort of an interesting tie to the citizens of Vermont, which sort of tied into Act 250. And that was sort of a different issue, but I don't think it, at least initially, didn't strike me as helping further define what is included in reorganization.
Okay, thank you. Anyone else have any question you want to get on the table whether we're trying to answer it now or just identify some things for us to learn a little more about before when we come back to this. All right, I'm not seeing any other hands, and it is 10:12, so that was a goal. Representative LaFave?
No, fine, I'm fine, thank you.
Okay. So with that, I'd just like to say thank you to everyone for participating this morning and deepening the conversation. And I will be in touch with Chair Sheldon, and so that we try to keep the two committees a little bit in sync as we work, even though there are individual questions to each committee. So it's good to see you all, and thanks for pitching in as it was a perfect opportunity to have a joint meeting. So thank you again.